It can be sorted properly. Yes.
Item 29 has written.
Sorry, sir.
Item 29.
29.
Right.
Page wise, sir. I'm coming.
Supplemental list, page 1, 1 to 10.
Well, item 4.
4, sir.
Next week, I take this one.
Other side in absence of.
Like, other side, admission नहीं निकल.
No, no. The wrong concept. Admission no other side appear kale.
Appear कर दीजिए ना alright.
So don't advise that way. अरे गोटे आरंभ गोटे भूल भाल आरंभ करिया ठीक हो तीन जगह बेले पड़ गोटे भूल कथा कहले एडमिशन नहीं अदर साइड अपियर करे ताना सुनिबे तम पार्टी काई करछन
ना मु ताको पार्टी कोन स्टेट इज द पार्टी
स्टेट इज द पार्टी
ऑलराइट
मोर ठीक चलची माने
माय लॉर्ड आई एम सॉरी सर
how you are spending your nights I do not know but for me it has been very hectic. God is so kind towards me still. EPCL रे आपण उदे इन्फॉर्मल पार्टी करथिबे
यस यस
कोन है मिस्टर प्रधान कोन है यू टेक केयर ऑफ योर फ्रेंड
से ट्रांसफर पे मागुछु
हां जे नहीं बट से कोई पार्टी है नहीं
नहीं पार्टी
everything is somehow incoherent and
ऑलराइट
he has already been examined at PW3 what is the question of apprehension and the threatening or tampering that
सेटा तो पचार जे आपण काहा को से जानछन से एडजस्टमेंट करले तो मो he could not handle my yeah that is how whatever पण का apprehension सेठी एक्सप्रेस कर म्हणजे ताकर जे जति इंटरफेयर करछन इट विल बी अफेक्टेड
यस किछि इंटरेस्ट सैंपल होता है नेक्स्ट वीक आसु
होची डॉक रे कहिबे इज ए हिंट एज ए लॉयर डॉक रे सीधा कहि दे देखिया केमति के तो आपण धकेबो ये डेट सर एग्री टू डेट सर
नेक्स्ट वीक आसु
नेक्स्ट वीक
1 वीक आफ्टर आसु
नहीं 1 वीक सर नेक्स्ट वीक भी आसला हो
We come
जेते दूर जो आपण पय भलो
आगे
6-7 वीक रस
यस ओबले
Item 1 may be taken up 1 week.
वन के मेंशन करछन फिर आपण कोन हला ठीक अछि वन डेट कर दियो
Yes.
पैसा दोना हती तो ये ना कोन
No.
पैसा दोना हती तो
No.
comes in 6 sir.
बाहर जो आर्गुमेंट हे करो बेटा मते कहितले इथांते ना इट लीड्स टू नो वेयर एक्चुअली से कोइ विथड्रॉ कर देन जे कोचन जे अपन एग्जामिनेशन विथड्रॉ कर दियो
Page 2, 11 to 21.
वन टा केबे सेटा रखिबे अपन एज ए लॉयर यू शुड एडवाइस योर क्लाइंट दिस हाइड एंड सीक गेम विथ कोर्ट ऑर्डर्स विल नॉट हेल्प हिम
Right.
ही हैज टू हैंडल इट
Yes.
अपन के से जो ऑर्डर हिची ए बेंच अर्जन करिवे ए करिवे से करिवे दैट इज नॉट द लॉ एंड दैट इज हाउ यू इंट्रोड्यूस योरसेल्फ एज ए लॉयर be firm on the legal issues they will respect you otherwise they will never respect you they will treat you as their agents that is the beauty of this profession you can tell truth on everyone's face anyone's face however big or small he may be satota koi debe sita
Yes.
he has a liability to pay
Right.
Item 12 and this kitchen. It's on behalf of waiver.
it's a good as who matters sir
Oh, item 12.
nahi jaini 10 रे अछि
Page 2,
आज सकाळ कोन एफर्ट सो चल
11 to 21.
Item 12, my lord.
12 कोन सर
Removal.
इफेक्ट रिमूवल पे टाइप्स आर ऑर्डर से सेति नियंतिनी गोटे कॉन्शियस एई प्रैक्टिस रे गोटे कॉन्शियस हेबे जहा नै ता कहबा इसी हम पाखो सब यंगस्टर्स बसचंती एई जिंसोडा को तांको मन को आंदोलित करूची जे ऑर्डर से आपण डिफेक्ट रिमूवल अछि 4A9 आपण तो टाइम मागिबे सकाळ
Time put a सप्ताह कर देबे
सेटा कहबे आपण ना सर कोन
मन मोर पावर नाही ऑन बिहाफ ऑफ बीवर
आपण ना किंतु मो पावर नाही किंतु से ना आपण तो डेवलप हेनी
जीबी परिडा गोलक
आज्ञा।
जीबी परिडा
जीबी गोलक बिहारी
गोलक बिहारी परिडा
एते बढ़िया देखो मु गेस भी कर दउ छी आपण को ना नाही
माने पावर रे
आपण जा पावर जे कार नाही ऑन बिहाफ ऑफ बामदेव बराड
वामन
ठीक है there is never sir orders matters sir arjan amar aguru ete strict like कहला माने हमकु तापरे कोर्ट छाडी जे एते डर ऊपर पार्टी को गाली सुनुचु कोर्ट छाडी पडुचु तापरे जस्ट इमेजिन हमें जे कोटे कोर्ट सकाळ ऑर्डर्स मैटर मेंशन करिवु ठीक अछि 1 week
1 week.
डेट करो तो सर ऑर्डर डका 1 week टाइम दियंतु
We come see there, sir.
तेरो सर यस प्लीज 13 रु 21 22 रु 30
Madam, item 30, madam. On behalf of Mr. Haraprasad Ratha, may be taken up next week, madam.
काउंटर फाइल करदेले सित पे मध्ये असुविधा गेला 30 टा कार मिस्टर महांती आपण एक्टिव हे जातो मिस्टर नायक 30 टाइम मागले काउंटर दे दिसिन से टाइम
Reading select complete.
इतोडे हमर गोटे भूल हे जायछि ऑर्डर टाइम में भूल टाइप करछ ना केबे डेट करंतु
We come see 3 years.
योर नेम सर
Rajkumar Sutar, RK Sutar.
the new latest spin bowler Sutar is bowling brilliantly. You have to be like that.
Thanks.
You look to be new. So, Rajkumar Sutar. Can I order करे पड़े वोटे typographical error registry has pointed out. हमारा actually date number रे बहुत भूलभाल ही जाउची. So, तो कर दबा ठीक अछि. इनी आठे रहइबो. एथिरे 30 रे किए मिस्टर नायक आपण एसी आज्ञा अच्छा चली ପରେ ମୁଁ ଡାକି any on page 3 to page
29 becomes infectious.
29 sir to PC Das other side Baisakh ଅଛନ୍ତି ଆଚ୍ଛା yes
I think it's whole matter. Recovery of wrongly promoted and recovery of salary.
ସି ତ withdraw କରୁଛନ୍ତି sir
They're withdrawing.
हाँ.
That's fine.
ମୁଁ ସେଥିପାଇଁ କହେ ଯେ ମେମୋ ଦେଇଛନ୍ତି ଆପଣ କପି ଦେଇ ନଥିବେ
Nah, I'm not saying
ଆରେ ଅଦର ସାଇଡ ଡିଜର୍ଭସ୍ ଏ କପି ହି ଇଜ worth a lawyer ନା ନାହିଁ
They are mentioning the
he
code.
has started arguing as if you have adjourned the matter କପିଟା ଦିଅନ୍ତୁ ନହେଲେ ଆପଣ ଗୋଟେ ଜେରକ୍ସ କରି ସାରଙ୍କୁ ଦିଅନ୍ତୁ ସର ପ୍ରଭାତ କପିଟା ଗୋଟେ ଦେଇ ଦିଅନ୍ତୁ ସାର୍ ଆପଣଙ୍କ ଏକ୍ସଟ୍ରା କପି ଅଛି
ନାଇଁ ନାଇଁ
ସେ ଦେଇଦେବେ
ସିନ୍ କରିଦେବ
ହଉ ହେଲା ନା ସିନ୍ କଣ କରିବେ କପି ନ ଦେଇକି ସିନ୍ କରିବେ ଆହୁରି ଷ୍ଟ୍ରେଞ୍ଜ ସେ ଦେବେ
I get it.
ଆପଣ ଟିକେ ଜଷ୍ଟ गिव हिम सम टाइम
I get it.
ये एनी अदर मैटर 25 मिस्टर मान अच्छा
I'm very sorry, this is late to expert today. So only for the 29, it's Monday. I mentioned
अच्छा रिटर्न ऑफ डीडी
I will inform to the
अदर साइड
Yes, I come to Mr. Gupta later. I will inform.
ठीक है नहीं एटा तो आपण यू आर द पिटिशनर एते एडजमेंट नेले किछ असुविधा नहीं କିନ୍ତୁ डिफेक्ट रिमूवल पे एडजमेंट नेबे
29.
से केबे आपण
We come see 6 sir.
6-7 ना आउरी आगु दरकार
29. खाली कोई डीडी टा खाली रिटर्न करी
29 रे
आगे
आज के तारीख नहीं
24.
नहीं 29 से तांकर कारण अछि से रखचंदी 127 टा मैटर तो से वीक
मैं काली आसी
आसु 6-7 रे ना 13-7 केबे सुविधा 6-7 कर दियो any other matter in case 32 ଆପଣ
34 ଟା ମୁଁ ଗୋଟେ region
बस 1 second 32 मिस पटनायक
32 kindly taken up 1 week after my lord. In first case, I am for the petitioner.
हां से तो म सीबी कहन तो मुझ पे एक्चुअली कनेक्टेड मैटर आपण मिस्टर पंडा बड़ा सिंपली पोस्टिंग कर दो दैट विल सेव टाइम बड़ा पासिंग ऑर्डर 32 रे की स्टेट काउंसिल नाइक नेक्स्ट वीक आपण अपन नोटिस ये रखंतु एडजस्ट करंतु
मैंने that is a urgent matter urgent matter because a employee retired terminated
agree for a date unlikely to not likely to reach this week you have to accommodate for 450 have been adjourned up to we had a some difficulty in listing
starving condition है 5 वर्ष होला reinstatement order
पहले अंत्योदय अन्न योजना रे अप्लाई करंतु रीड फाइल करंतु यदि मिलुनी
सेटा सर्विस तो
आपनकर सुनंतु सर आप यू आर बीइंग वॉच मिस्टर सतपति यू आर सो स्मार्ट एंड इंटेलिजेंट इन इंडिया एट लीस्ट यू हैव टेकन केयर ऑफ स्टार्वेशन
that is fine.
ଯଦି ଅନୁମୋଦନ apply କରିବେ ଆପଣଙ୍କ free ration apply
ସେ
କରିବେ
ସର୍ଭିସ ଟା ରେଷ୍ଟୋରେସନ ପାଇଁ ଅର୍ଡର ହେଇଯାଇଛି।
5 ଟଙ୍କିଆ ଡାଲମା ଭାତ ନେଇକି ମୋବାଇଲ ଫୋନ ଧରିକି
ଡାଇରେକ୍ସନ ହେଇଛି ପରଚେସ ଦବାକୁ ସେ ଷ୍ଟେ ଅର୍ଡର ଟା ରହିଥିବା ହେତୁ
These are not available. ଆପଣଙ୍କର କଳାହାଣ୍ଡି has become the rice bowl of Odisha.
କଳାହାଣ୍ଡିରେ ତ ବଢିଆ ଚାଉଳ ବଢିଆ ଚୁଡା ମିଳେ।
Exactly. ଆପଣ just imagine କରନ୍ତୁ our childhood days 70s, late 70s, early 80s କଣ ଥିଲା
ପୁରା
situation.
ସେ
ଆପଣ
ଧଳା ଧଳା ଚୁଡା
ପ୍ରେୟାର କରୁଛନ୍ତି starving condition ରେ।
ସେ
ଯଦି ଉପାସ କରିବେ ଷ୍ଟ୍ରାଇକ୍ କରିବେ ଖାଇବେନି ସେଟା କଣ କରାଯିବ ତାଙ୍କୁ ଆରେଷ୍ଟ କରାଇକି ନେଇକି ହସ୍ପିଟାଲାଇଜ
6
କରାଯିବ।
ବର୍ଷ ହେଇଗଲାଣି ସେଥିପାଇଁ
6 ବର୍ଷ କାଇଁ ଷ୍ଟାର୍ଟ କରୁଛନ୍ତି କଣ ଦରକାର
ଦରମା ପାଇନି କିନ୍ତୁ ଅର୍ଡର ଡାଇରେକ୍ଟର ଡାଇରେକ୍ସନ କରିଛି
ଯିଏ
ଦରମା
ଦରମା ପାଉନି ଅନ୍ତର୍ଦୟ ଆପ୍ଲାଏ କରିବ। ମିଷ୍ଟର ନାୟକକୁ କୁହାଯିବ ଆପଣ ଷ୍ଟେପ୍ସ ନିଅନ୍ତୁ ଦେଖନ୍ତୁ କଣ ଆପଣ ଗୋଟେ ଆଣନ୍ତୁ ସେମିତି କେସ୍ ଆମେ ଖାଇବାକୁ ଦଉଛୁ କି ନାହିଁ ସଫିସିଏଣ୍ଟ ଖାଇବାକୁ ଅଛି ଆଜ୍ଞା ଭାରତରେ ସେଇ ଇସ୍ୟୁ ନାହିଁ ଗୋଟେ ସର୍ଟ ଡେଟ୍ କରନ୍ତୁ ମିଷ୍ଟର ଶତପଥୀ ହାଜ୍ ବିକମ୍ ଇମୋସନାଲ 20 ୱିକ୍ରେ
ଆଜ୍ଞା
20 93 ଆଜ୍ଞା ଅଛି ଅଲରେଡି so there is a purpose in distributing the matters.
Interim order to continue, my lord.
ଇଣ୍ଟି ମର୍ଡର କଣ ଷ୍ଟେ ଥିଲା ନା ନେକ୍ସଟ ଡେଟ୍
ଇମ୍ପ୍ଲିମେଣ୍ଟ ଲାଷ୍ଟ ଟାଇମ ଏକ୍ସଟେନସନ ହେଇନାହିଁ ସେମାନଙ୍କୁ
Till
ଆପ୍ଲିକେସନ
next
ଦବାକୁ ଲାଷ୍ଟ ଟାଇମ
that's a chance ଠିକ ଅଛି ଇଣ୍ଟରନି ମର୍ଡର ତାହେଲେ ଆপিୟରାନ୍ସ ଦେଖିବାକୁ ପଡିବ ତେଣୁ ବବିତା କୁମାରୀ ପଟ୍ଟନାୟକ ଷ୍ଟେ ଆପଣ ମିଷ୍ଟର ଶତପଥୀ ଆପଣ କାହା ପାଇଁ
ଆମେ ଅପୋଜିଟ ପାର୍ଟି
ଏଥିରେ ଆପଣ ତ ପିଟିସନ ନୁହଁ ଆପଣ କାହିଁ ଖାଇବାକୁ ପାଉନାହାନ୍ତି
ନା ମୁଁ ପିଟିସନର ହଉଛି ମୁଁ ଏମ୍ପ୍ଲୟି ମୁଁ ଯାହା ଟର୍ମିନେସନ ସେଟା ସେଠି ହେଇଯାଇଛି ଡାଇରେକ୍ଟର ରିଇନଷ୍ଟେଟମେଣ୍ଟ କରିଦେଇଛନ୍ତି
ଏଇଟା କଣ ଟ୍ରିବ୍ୟୁନାଲ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ
No, my lord. I am for the managing committee, my lord.
ଆପଣ କୋଉ ଅର୍ଡରଟା ଚ୍ୟାଲେଞ୍ଜ ଡାଇରେକ୍ଟରଙ୍କ ଅର୍ଡର
Director order.
ଖାଇବା କଥା ଟିକେ ବୁଝନ୍ତୁ ଆପଣ ଯୋଉ ସ୍କୁଲରେ ଯୋଉ ଫ୍ରି ମିଳୁଛି ଖାଇବାଟା ମିଡ୍ ଡେ ମିଲ୍ ତାଙ୍କୁ ଆଟଲିଷ୍ଟ ଦିଅନ୍ତୁ ଯଦି ଆପଣଙ୍କର ପିଲାଙ୍କ ଛଡା ଆଉ 10-20 ଖାଉଛନ୍ତି 21 ଜଣ ଖାଇବେ ସେଥିରେ କଣ ଅଛି
ସେଟା ବି ହେଇଗଲା ହେଇଯାଉଛି
27-26 ପ୍ରଶାନ୍ତ କୁମାର ଶତପଥୀ ସେକେଣ୍ଡଟାରେ ମିଷ୍ଟର ପି ପଣ୍ଡା
ପିକେ ଶତପଥୀ ଦିଟା ସେକେଣ୍ଡରେ
ନାଇଁ ସେକେଣ୍ଡରେ ତ ଆପଣଙ୍କ କଣ ପାୱାର ନାହିଁ
ମୋ नो ऑब्जेक्शन ଆସିକି ଆସିଥିଲା ଏକେ ପଣ୍ଡେ ସାର୍ ଆपिୟର କରିତେ ତାଙ୍କର नो
ଆପଣ ଶୁଭ ସନ୍ତୋଷ ହଉଛନ୍ତି ଆପଣ ହଉଛନ୍ତି
ଦ ଏମ୍ପ୍ଲୟି ଟିଚର
ଠିକ ଅଛି ଆଚ୍ଛା ମିଷ୍ଟର ପାଣ୍ଡେ ଆपिୟର କରୁନାହାନ୍ତି ଆପଣ କହୁଛନ୍ତି
ନାଇଁ ସେ ତାଙ୍କଠୁ ଏନଓସି ଆସିକି
ଆଚ୍ଛା ଠିକ ଅଛି ଆପଣ 13/7 ଆପଣଙ୍କର ଯେଉଁ ସେ ଖାଇବାକୁ ପାଉନାହାନ୍ତି ସେଥିରେ 117ଟା ଲିଷ୍ଟ ଅଛି ଆପଣ ତାକୁ ଆଡ୍ କରି କରିଦେବେ ଆହୁରି 100-150 ହେଇଯିବ ଇଜ ଇଟ୍ ପସିବୁଲ ଏ ଯୋଉ ଯାହା ଆସାଇନମେଣ୍ଟ ଅଛି ତାକୁ ଯଦି ଏଠି ଫ୍ରେଶ ଆଣ୍ଡ ଅର୍ଡର୍ସ ମ୍ୟାଟର ଆର୍ ବିଂ ହାର୍ଡ has to be hard ହିୟରିଂ ନ କଲେ କଣ ହବ ସବୁ ଯାକ ତ ଇସ୍ୟୁ ନୋଟିସ କରିକି ତ ଛାଡି ହବନି ଦେଖାଯାଉ
Item 34 below.
ନାଇଁ just one second I'm just checking the appearance ପ୍ରଶାନ୍ତ ଶତପଥୀ ଷ୍ଟେଟ ପାଇଁ ଦିଟି ଜାଗାରେ ମିଷ୍ଟର ନାୟକ ମିସ୍ ପଟ୍ଟନାୟକ you are not there in the second matter
No, in first matter,
ଠିକ
I'm
ଅଛି
appearing.
ଆପଣ କରନ୍ତୁ ଠିକ ଅଛି 33 କଣ କହୁଥିଲେ
Item 34 below, I will file rejoinder.
my lord, interim order.
ଟୁ କଣ୍ଟିନ୍ୟୁ
ଇଣ୍ଟିମେଣ୍ଟ କାହିଁ କଣ୍ଟିନ୍ୟୁ ହେଇନଥିଲା
ବର୍ତ୍ତମାନ ଅର୍ଡର ପାସ୍ କରୁ
ଆଜ୍ଞା ବର୍ତ୍ତମାନ
34 ରେ କଣ ସାର୍ ପ୍ରଧାନ
Sir, rejoinder ଟା file. ମୁଁ counter ପାଇଛି.
ପାଇଲେ କାଉଣ୍ଟର
ଆଜ୍ଞା rejoinder file କଲେ 2
ସିମ୍ପଲି ଆଡଜର୍ନ କରିଦଉଛି ଅର୍ଡର ପାସ୍ କଲେ ଇଟ୍ ଟେକ୍ସ ଟାଇମ୍ ଆଣ୍ଡ ଅପଲୋଡିଂ ଏଭରିଥିଙ୍ଗ
ହଁ
34 ଟାକୁ ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ
वो कौन से 3-8
3-8 oblige.
yes
Item 35, my lord. I put on
35.
page. My lord, I'm appearing for opposite part number 2. I have received the IA.
ପଟ୍ଟନାୟକ ଥିଲେ ତ
Well, yes, my lord. My lord, I have filed the IA because, my lord, the pleading has already been exchanged, my lord.
Yes.
It was referred to the mediation center. It was become unsuccessful. Then, my lord, they have filed execution application, my lord, during pendence of this writ application, my lord.
ଆପଣ ଟିକେ ଏକ୍ଜିକ୍ୟୁସନ ଟିକେ ରୁହନ୍ତୁ
I'll give them instruction. I have received the IA today, my lord.
now
Now,
instruction ନୁହଁ ଏକ୍ଜିକ୍ୟୁସନ ଟାରେ ଆପଣ you have to stop there
my lord,
ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ କୋନଟା ନେବେ
my lord,
you have to prevail over your client or the client will prevail over you
my lord, I'll inform them.
and it cannot be a legal strategy ଯେ ଆପଣ ଏଠି ରିଟ୍ ପେଣ୍ଡିଂ ଥିବ ସେଠି ଏକ୍ଜିକ୍ୟୁସନ ହଉଥିବ you must understand that
Yes, my lord. That I completely bow down, my lord.
In
That
the
I'll
execution petition itself, my lord, they are suppressing the fact the writ petition has not been pending. That has been filed, my lords.
ଆରେ ସେଇପାଇଁ ତ
Yes, sir, lordship, I understood, sir.
ଆପଣଙ୍କୁ ଫିସ୍ ଦିଆଯିବ ଆପଣ ଯେ କୋର୍ଟରେ କହିବେ ଆଜ୍ଞା ରିଟ୍ ପେଣ୍ଡିଂ ଅଛି
ଆଜ୍ଞା।
ସେଠି କହିବେ ନା
Again.
so don't proceed with the execution
My lord,
ଏଟା କେବେକୁ ପୋଷ୍ଟିଂ ହେଇଛି ଡେଟ୍
That aji achi execution proceeding.
ଆଜି ଅଛି? Sure.
Yes, yes, I'm sure. ଆଜି ଅଛି।
ଲାଗୁନି?
ଆଜ୍ଞା ଆଜି ଅଛି ଆଜି
Can I record that it is posted today?
yes my lord yes
ଆଜି କେତେ ତାରିଖ?
24
The execution proceeding ଟା କୋଉଥିରେ ଅଛି? Permanent ଲୋକ ଅଦାଲତରେ?
no my lord this on civil judge senior division Bhubaneswar
35 ଲେଖନ୍ତୁ Mr. ଅନନ୍ତ ନାରାୟଣ ପଟ୍ଟନାୟକ for the petitioner, Mr. Nihal Ratha for the opposite party. आइए कितना नंबर आइए?
plus the IA number 10911 of 2026
आइए लिखिए 10911 of 2026. The matter is listed for hearing under the heading for admission. The IA has been filed stating therein that the opposite party number कितने Mr. Ratha?
I'm appealing for opposite partner 2, my lord.
Copy number 2 is proceeding with the execution during pendency of the writ petition. The learned counsel, Mr. Ratha, appearing for the open number 2, requests for copy of the application. Copy has been served.
Yes, sir.
This shall obtain instruction. But it is stated by the learned counsel, Mr. Patnaik, for the petitioner that the execution is posted today before the learned
before the learned civil judge senior division Bhubaneswar
division
Bhubaneswar
Bhubaneswar.
Balas.
1 2 kichhi nahi.
well they said
Civil judge
civil judge.
Bhubaneswar. Stop. Accordingly, it is directed upon a prayer being made comma the execution matter. That number ta koi pari?
yes my lord 63 of 2026
Ite lekha hai.
yes my lord. execution petition I have annexed
The details dete arising out of it shall be adjourned to a date. Eta apna 35 ta kebe ko ani pari? Adjourned to a date beyond 3 8 question. Beyond 10/8/2026 as would be convenient to the court, the court in session of the matter. The matter shall be listed for admission in the week commencing 3 8.
Yes, my lord. And pleadings are complete, my lord.
Let us hope.
yes
Yes, sir.
Yes.
Much obliged.
great
Grateful.
आपण कोण हिअरिंग होईल म्हणजे एज्युकेशन फाईल करतले की स्टे हवं
ସେମାନେ imprimor file କରିଥିଲେ।
that is a smart strategy. That is how you should think. That is more like a lawyer than yes.
great
Well, much obliged.
Item to
ଆମର ये जो मंगलवार गुरुवार हबार थिला कोन बीसी हबो नोटिफिकेशन किछि नै एटी चलिबो त मोटे देखि नै देखि नोटिफाई सब इन पर देखियो आपकी को कोने पर तू सर सामान ये अछंती देखिबे शिवानंद सामल PR नाइट टीके साउंड कॉल करो तो पासवर्ड कर दियो
item 3
Madam, I'm in virtual. And the land acquisition appeal,
Mr. K.
Appeal.
for the petitioner sorry এটা appellant এটা ଆପଣଙ୍କ sir IA ଟା होची 45 IA 45 of 2025 along with LAA 5 of 2025. The IA has been filed by the appellant seeking exemption of court fees. Mr. Manti, copy अछि?
yes sir
Kali copy nathila Mr. Naik. Copy of the IA has been served on the London Additional Standing Council.
the
AK Jena for
noting
the
of magazine.
Mr.
The noting of
Additional
magazine.
Standing Council for the opposite respondent. IA रे लिखिबे petitioner. Sir, कौन पहले sir? Please kindly repeat. I could not. I mean.
And you see the notings matter because
Yes. That instruction नहीं था. Copy has been served. The London Additional Council has adjournment to obtain instruction and file his response if so advised. आपण written instruction दियंतु जे exemption पे है ना so that exempt ही पड़ी. And file his response के लिए if so advised से काटी दियंतु. Stop. आपण project proponent को पार्टी कर चेंदी Mr. Jena.
Yes, madam.
Announcement by the-
Made party. Yes, the executive has been made party.
Executive Conductor Division,
Respondent two.
ठीक है.
Yes.
ठीक. The matter shall be listed for orders in the week commencing. Mr. Mahanti. Give it. ठीक है. In the week commencing 27 है. 27 है.
Yes,
Yes.
madam.
Item 5.
होता है नहीं पढ़ातु नहीं जोटा सिंपली हो पारियो तो करन आउ तरे फेरे
Item 5.
आपण पोस्टिंग डेट रे कंप्यूटर रे कले होउची तो ना आपण कर देले सियाडे लिस्ट ही पारु ठीक है 5 पार्ट्स ओवर कर देन ठीक देखा जानो
Item 6.
Your Lordship.
यस
Lordship, we have filed two transfer petition,
for the petition
6 and 7.
yes
Lordship, we have filed, one is the custody case and second is the divorce case filed by my husband.
custody filed by
Filed by husband. The custody of
by
the
the child
Yes, Your Lordship. We do not have any visit. He has completely blocked our access to the child.
but the problem is that this court doesn't have jurisdiction to entertain custody matters custody has to be the statutory forum ଆପଣଙ୍କର जो what is that those whatever acts are there
Yes, Your Lordship.
minority and guardianship act
Yes, Your Lordship.
it can be a 26 in a
Yes, Your Lordship.
13 application
Yes, Your Lordship. Both the petitions are existing in the.
why you are filing a separate TRPC
Your Lordship, we have filed this TRPC to transfer the case from Family Court Bolangir to Family Court Bhubaneswar. So my parental house is at Jajpur, but
no that's not the question you have not
Yes.
then you have not followed the question if 13 application is filed
yes, Your Lordship.
which is the section for custody
Our interim petitions can be filed under section 26
26
of the Hindu Marriage
so
Act.
if you want if you have filed there is only one application for separation is 13 has been filed by the husband
Yes, Your Lordship.
you have filed 26
Yes, Your Lordship.
so then why two transfer applications That
Your
was-
Lordship, my husband has filed another custody case under section 10 of the Guardianship and Wards Act for the custody of the child. That case is not filed by me. Both the cases has been
But
filed
you
by
are
my.
saying that the custody is with the your husband
Yes, Your Lordship. The custody is with, there is no order with regard to the custody. The physical custody of the child at present is with my husband, but there is no order to that effect. Even after having the custody, he has filed a custody petition.
that should have been your opening statement
Yes,
because
Your
that
Lordship.
has led to the confusion and I am not finding any fault
My apologies.
but
Your
obviously when you say that 13 is there and custody is there
Yes, Your Lordship. So he has filed the.
take notice
Yes, Your Lordship. Your Lordship, the interim petitions of custody of under section 26, which has been filed by me also, it is at the stage of hearing. So the matter may be stayed in the lower court because I am not being able to participate in the proceeding and the child is.
completely what you are saying is completely against the interest of your client you want your interim application for interim custody is to be stayed
No, Your Lordship, the section 13 application and the main custody case, which is the GUA case number.
no kindly appreciate the question don't lose concentration
Yes, Your Lordship.
you are saying your husband has filed the application for custody
Yes, Your
he
Lordship.
is having physical custody
Yes, Your
Correct.
Lordship. Your,
you have filed an interim application for interim custody
yes, Your Lordship.
that should be stayed
Your Lordship, I may just be given. There are two separate transfer petitions. The section, the transfer TRPC number 151/26. This is filed to transfer the guardianship petition case number 9 of
Filed by
2024, filed by my husband.
so in that petition you have filed a IA for interim custody
No, Your Lordship, my IA is
Wait.
pending before.
Just check the YouTube there's
Yeah.
the advantage of you are saying you have filed an interim application in the GUAP filed by the husband
Your Lordship, my interim application is pending under the section 13 of the Hindu Marriage Act, which is arising out of the TRPC 152. The Hindu Marriage Act in TRPC.
interim application for custody
Yes, Your Lordship.
why should you when there is a GUAP application already
Your Lordship, this was
You see,
filed first.
you can fast second. It's not fast second. You can have your claim in the appropriate petition.
Yes, Your Lordship.
You can have a counter claim. Have you filed that?
No, counter claim is pending, Your Lordship. The interim petitions are pending for
You
hearing
followed. What counter claim?
for the custody of the child.
Which petition?
Under the Guardianship Words Act.
You have understood it.
Yes, Your Lordship.
So what you are saying is not correct.
Your Lordship, I am seeking for the.
If I start dictating in those lines, my order will be conflicting. First line will be contradicted by the second line. Second line is contradicted by the third line.
Your Lordship,
You have to obtain clear instruction. I think there is some problem. There is some confusion.
Your Lordship, if I may be.
Because if I record these things, because I try to record everything.
Yes, Your Lordship.
So my order will be really, confusing.
Your Lordship, my humble prayer is to stay the divorce petition, which is under section 13(1) IA.
That is another thing. But if you are not having the custody,
Yes, Your Lordship.
because what you are saying will be recorded also.
Yes, Your Lordship.
That though the GUAP has been filed by the father,
Yes, Your
the
Lordship.
custody is actually with the father, and you want the custody.
Yes, Your Lordship.
So
Your
you
Lordship,
should
that is
have
the facts of the
counterclaim.
case.
You should have the
Yes,
written
Your
statement and counterclaim in the GUAP application itself,
Yes, Your
not
Lordship.
here. Anyway, you have to be clear in your facts.
Your Lordship, my
TRPC 152 is for
for the divorce.
and 151 is
151 is the Guardianship Words Act. Guardianship petition, case number 9 of 2024, Your Lordship.
the petitioner before this court is the mother of minor child born from the wedlock with the opposite party. The opposite party, father of the child, has filed GUAP. ଆପଣଙ୍କର draft ଆପଣ ନିଜେ କରୁଛନ୍ତି ନା ନାଇଁ ଆଉ କିଏ କରୁଛନ୍ତି ଆପଣ?
Your Lordship, we have the draft, the TRPC is filed by us, Your Lordship, but
Not us.
by me, Your Lordship. But
Did you have an interaction with the client person?
yes, Your Lordship.
ନହେଲେ କଣ ହୁଏ ନା ଆପଣଙ୍କର law firm ରେ problem ହୁଏ.
And I had personal interaction.
ଯାହା ଲେଖିଥାନ୍ତି ଆଉ ଯାହା facts ବୁଝି ପାରନ୍ତି.
I bowed down, Your Lordship.
Bowden,
But the original petitions
I
were not
don't
filed.
understand that why this apparent conflict of facts. Your statement before the court, the prayer and the interim prayer does not match. It has to be complete simple flow. Has filed GUAP 09 of 2024 before the learned judge family court Balangir. Se copy petition da copy achi.
Again, sir.
On the section 10 of the Guardians and Wards Act 1890. You have named your child Yudhant and you are having your worst kind of fights. At least he should have motivated
Your Lordship,
parents not to hide.
only for the sake of my child, I did not file any case against my husband. Your Lordship, to be very honest, I did not file any case. I always tried to reconcile my marriage. It was a love marriage. I always tried to reconcile.
Service. Telling these emotive things to the lawyer should lead to more questions, probing questions from the lawyer. Then why she has not filed the application? Somebody is able to come to court, contact you and file an application, then once she has not filed the custody application.
Your Lordship, custody.
She has to.
Yes, Your Lordship.
So she has not filed.
Your Lordship, in the DV case also custody.
Of the minor child born from minor child. Stop. It is submitted by the learned counsel for the petitioner. It is submitted by the learned counsel for the petitioner that though the husband, the father of the child, husband of the petitioner, has filed the custody application. Custody application, no, has filed the application seeking custody. But actually, the physical custody of the child is with the father himself. Interim custody
No, Your Lordship.
It's an old application.
No, Your Lordship.
On being asked, it is submitted that as per her instructions. As per the instructions received. the father has not been granted interim custody by any court. Stop. Para. We submitted that the petitioner, mother of the minor child, wife of the opposite party husband, has stays with her parents at Bhubaneswar.
No, Your Lordship. I am staying here alone. I was seeking for a job and I am
Stays at Bhubaneswar after her marriage has gone into rough weather. She is not maintained. Maintenance
No maintenance has been
by the
ordered.
opposite party husband. Stop. Stop. Hence, the prayer for transfer of the application from Balangir to the court of Judge Family Court. Transfer from the Family Court Balangir to the Family Court Bhubaneswar.
Yes, Your Lordship.
Kota. Stop. Issue notice along with this order. And pendency of the IA cannot be it's not in sync, so I have to avoid that also. Upon the question, IA file is interim custody fine by counter claim, whatever.
Yes, Your Lordship.
But you are seeking stay of this.
Lordship, I am seeking stay for the original case.
Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 or 5.
Your Lordship.
How many days you will take to file requisites?
3 days.
Within 3 working days. Returnable date we fixed to 27/7/2026. The matter shall be listed for orders in the week commencing 3/8/2026. IA. Hard learned counsel for the petitioner. She reiterates her submissions as noted above. Stop. So, para issue notices above, accept one set of process as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. Stop. In the interim, it is directed that the GUAP guardianship petition, guardianship petition number 9 of 2024. जोटी लिखिथिबे जीव सेटा को चेंज कर देले बदे जीव अपील हेले हबो जीव गार्डियनशिप पिटिशन 9 of 2024 pending before the learned judge family court Balangir shall be adjourned to a date beyond 10/8/2026 as would be convenient to the learned court in session of the matter upon a prayer being made for the state purpose. Then 152 appearance in Royala. The matter is taken up along with the TRPC number 151 of 2026, wherein notices have been issued. Stop. The petitioner before this court is the wife in the marriage. She seeks transfer of the MAT case number 65 of 2024 pending before the court of Judge Family Court Balangir to the court to the Family Court at Bhubaneswar in the district of Khurda. It is submitted that after the petitioner's marriage has gone into rough weather, she stays at Bhubaneswar in search of job. She is distressed, not being maintained by the opposite party husband. It is difficult for her to attend the matter at Balangir. Each sentence is difficult for her to. Issue notice along with this order. Requisites for issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. A returnable date be fixed to 22/7/2026. The matter shall be listed in the week commencing listed for orders in the week commencing 3/8/2026. Stop. Para. IA 164 of 2026. Hard learned counsel for the petitioner. She reiterates her submissions as noted above. Issue notice as above. Stop. Para accept one set of process fee as well as postal requisites. Returnable date as well as the next date of listing shall be as directed above. Stop. Bara.
2026 filed under 13(1) of Hindu Marriage Act.
How many cases she has filed against the husband?
Madam, till that she has not filed any case, madam.
You take notice. Amlan Shakti Pal for the Likhle. Opposite party blank. The petitioner before this court is the wife in the marriage. C6 transfer of CP number 54 of 2026. Pending before the learned judge, family court, Balasore.
Yes, madam.
The said CP, EU sentence actually complete. Sorry. The CP has been filed by the husband under section 13(1) of the Hindu Marriage Act seeking seeking dissolution of marriage solemnized between the petitioner and the opposite party on 2019 and decree of divorce, or as well as grant of decree of divorce. Stop. They submitted that ground corner, Mr. Pal.
My lord, distance and another thing, my lord, 4 years girl child is there, my lord.
CPC re ko provision ଅଛି girl child jibo court ko.
My lord, see, now the petitioner is staying.
Now the kona EJUG ta samaste kouchenti girl child, minor child. So seita how the court can direct that the girl child will be carried. It is easier to carry the girl child at the place.
My lord, there is no one to look after the girl child, my lord.
So the child has to be left in the crèche or some ashram.
My lord, is small.
I should to carry the child, small child to the court. So you follow the question?
Yes, my lord.
When I pass such kind of orders,
My lord, another
my lord, but upon answer that you to my lord कहले कौन?
she is unable to do anything, my lord.
Then why she should prosecute the High Court and come here and prosecute a litigation?
My lord.
My lord.
No, my lord.
She wants to carry the child to the court.
Yes, my lord.
That is your submission. Why she should carry the child to court?
Otherwise, my lord, there is no one is to look after the child, my lord.
Why should that be? She has to be left in the crèche. She is not. The child is not being educated.
My lord, 4 years child, my lord.
So, do you have kids yourself?
Yes, my
So
lord.
when did you get your kid admitted to school?
At 4 years, my lord.
3
years, my lord.
No lawyer in Cuttack is leaving the child at home.
Yes, sir.
So these sort of absurd arguments should not be there.
Yes, my lord. But apart from that,
जोठी भी आपण कोठी की चाहुचो
ମୁଁ ଚାହୁଁଛି ଭଦ୍ରକ, my lord.
भद्रक रे
ଆଜ୍ଞା.
same logic applies भद्रक रे कोर्ट रे चाइल्ड को नै कि जिबे
ଛୋଟ ପିଲାଟା ଆଜ୍ଞା ଅଛି.
कोन मु बुझी पाउने
ଆଜ୍ଞା.
what is the you are a lawyer or you are a
Yes, madam.
this is a drawing room discussion मोर गोटे छुआ बहुत असुविधा होची मु ताको भद्रक रे ले कोर्ट नै कि जिबी.
Apart from
You must understand that.
Yes, my lord.
Is the child summoned to court?
No, my lord.
Is it a mandate of the statute that the child has to be carried to the court?
No, my lord. That is.
Then what is this?
Distance and another thing, my lord.
Having a minor child is a condition to have a nearby court. Suppose the court is next door to you. Then Bhadrak also it is difficult. Bhadrak, what is the address?
Address is, my lord. Jamkunda. Village Paljamkunda. Village Paljamkunda, Baliapad, PS.
What is the distance between Baliapad and Bhadrak?
Approximately 10 to 20 kilometers.
You belong to which district?
I am Khorda.
Eh?
Khorda, my lord.
So don't argue like that. Must apply your common sense.
Yes, ma'am.
Google check kar le distance between Baliapad and Bhadrak. Sanu. 122.
No, my lord. But 20, my lord. Sorry, my lord. At post 20 on PS Bhadrak, rural. My lord, but that is.
Say Chunti ta habo 12-13 kilometer.
Yes,
12-13 kilometer carry kara, you have to leave the child somewhere in some custody. Tankara papa, ma, bhai kehi nahanti. You have to leave the child mamu hore kai rohanti. पाठ पढ़े में काई रखंती पिला एटी पे रखंती जोटी हस्बैंड वाइफ थांती स्टिल मामू रे छाडंती. These are absurd. You are arguing the absurdity. लक्ष्य है आपण बाल्यापाल को माने मोर माने ऑर्डर रो माने
sorry
people would have laughed at me.
Sorry my lord. Eta
He submitted that the petitioner after her marriage has gone into rough weather. Se Bhadrak re tanga ghar kouthi ta Bhadrak rural le rahuchନ୍ତି.
Yes, my lord. Chunti, village Chunti.
Are agya Bhadrak rural le kiye rahuchanti village Chunti?
With her parent, father-in-law and mother-in-law. Bappa ma se to.
In-law nuho.
Sorry, father and mother.
Tal kuch ghare kiye nahanti fer argument kalen.
You want to look up.
First line is contrary to second line. Second line is absurd. Third line is contrary to both first and second line. Good a semblance of respectability anantu. Amara jo activity ta, the conversation should have some semblance of logic and respectability. It is dictated.
Yes.
We don't have an option.
Sorry.
Upon jaha kohibe mu mor jaha kohiba seta ki din. We have to reproduce. Upon pleading thik rahibo. After the conduct has gone into rough weather, stays with her parents. So, at their village, at the village of the parents, at Bhadrak, that comes within the jurisdiction of Bhadrak Rural PS. She finds it difficult to attend the matter at Balasur. At Baleswar. ଏବେ ଯୋଉ latest notification ଟା ଦେଖିଛ spelling ଟା ଟୁଟା ଚେଞ୍ଜ ହେଇଛି ବାଲେଶ୍ୱର ଆଉ ନାହିଁ ବାଲେଶ୍ୱର ସ୍ୱର ବି ଚେଞ୍ଜ ହେଇଛି କେତେଟା ଚେଞ୍ଜ ହେଇଛି ସେଟା ଦେଖିବ at ବାଲେଶ୍ୱର ଆପଣ ମେଣ୍ଟେନାନ୍ସ ପାଉଛନ୍ତି
No, man.
ସେଇଟା ଆଗ କହିବେ ଆଗ ଯୋଉ ଫାଷ୍ଟ ଗୋଟେ as a small kid ସେଇଟା ଯୋଉ କହୁଛନ୍ତି that is nowhere it is there ଆପଣ ନିଜେ ରହୁଛନ୍ତି ପ୍ୟାରେଣ୍ଟସ୍ ଙ୍କ ପାଖରେ କହୁଛନ୍ତି ସ୍ମଲ୍ କିଡ୍ କୁ ମୁଁ ନେଇକି ଯିବି କୋର୍ଟ କୁ ବା ଭଦ୍ରକରେ ରହିବି ସୁବିଧା see the petition it is submitted that the petition is distressed as she is not being maintained by the opposite party husband and she doesn't receive any maintenance. Stop. She finds it difficult to attend the matter at Balasur. That's it. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within
5 days.
Within 5 working days. Returnable date be fixed to 27/7/2026. The matter shall be listed in the week commencing 3/8/2026. आइए 178/2026. Hard noted counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above. Stop. Para. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. So, para. In the interim, it is directed that the CP number 54 of 2026 pending before the Learned Judge Family Court Balasur shall be adjourned to a date beyond 10/8/2026. As it be convenient to the Learned Court in season of the matter upon a prayer being made for the said purpose. Urgent certificate copy. Urgent certificate copy be issued as per rules. Yes.
Item 9.
The Divyajyoti Sahoo for the petitioner.
I'm for the wife, my lord. Yeah. Petitioner is seeking transfer of CP case number 25 of 2026, which was filed by the husband from the Court of Family Judge Raigada to the Learned Judge Family Court Barampur, my lord. I have annexed that petition which was filed by the husband opposite party number 2, that is in Raigada.
Grounds, sir? How many cases you have filed against the husband?
I have filed one case.
Maintenance
case that is I have filed before the family judge Barampur, my lord, and I have annexed it as annexure 1 at running page 11, my lord.
A minor child argument? Having a minor child?
No.
today's opening, so you will
No,
not.
no, my lord.
You are staying with your parents
Yes, I'm staying
at Ganjam, Berhampur.
at Ganjam, Berhampur. I have filed my petition maintenance.
Which is the decision on these points? 125 जोतरे थिबो एवं maintenance file इतो. There is a decision.
Yes, that is a decision.
Yes. Had ordered counsel for the petitioner. The petitioner before this court is the wife in the marriage. She seeks transfer of the. You can take your seat. I'll dictate. She seeks transfer of the CP number 25 of 2026. Pending before the learned judge, family court, Rayagada, to the court of learned judge, family court, to the family court at Berhampur in the district of Ganjam. It is submitted that the petitioner, after her marriage, has run into rough weather, stays with her parents at Berhampur. She has filed application CR.P. number 25 of 2026. CR.P. number 111 of 45. ଆପଣ କଣ index ଭୁଲ କରିଦେଲେ ଦେଖନ୍ତୁ ଚେକ୍ କର ନାଇଁ ଆପଣ ସାହୁ
Yes, ma'am.
look at your index page.
Index page, my lord. Yes.
Annexure 1.
Annexure 1, copy of the CP. My lord, that is index ray again, sir. That is the mistake.
ठीक करिवे
Again.
तेरा बाय डिफॉल्ट बटन हेलाने जज ठीक करिवे ता बिल्कुल जज कर के संपर्क नै ता संगे
Again. सेटा
एसआर करछोंती देखुना
सेटा
से तापर स्कैनिंग करले से देखले
सेटा टाइपोग्राफिकल
टाइपोलॉजी सेटा अपन तो करिवे ना टाइपोलॉजी पे करेक्शन
again.
कौन लिखले 111 of 2026 seeking monthly maintenance under section 144 of BNSS Bharatiya Nagarika Suraksha Samhita as she is not being maintained by the opposite party husband. She finds it difficult to attend the matter at Rayagada. Stop. ये लिखला परे फर्स्ट पारा आउथरे इंसर्ट करिवे सभा ऊपर. It is submitted by the learned counsel for the petitioner that inadvertent typographical error has crept into the petition at the index page. आपण एटा कोन आउरी भितरे भूल करछंती कि
नहीं भितरे ठीक अछि
ना जोड़जा पाल्ला लिखले कोडी सीपी लिखा हला कोडी सीआरपी लिखा हला
नहीं भितरे at page running page 8 at running page 6 paragraph 8
नहीं सेटा आपण चेक करंतु. I don't want that information. I am checking because there may be other
only in the
mistakes also.
index page that is incorrect, but in other averments I have taken correct, my lord.
पुराटा देखि दो अब नहीं मते लागु ठीक अछि. Page 6 para 8 says para
CRP 111
wherein at serial number 1 annexure 1 the annexure has been mentioned to be CP number 25 of 2026 instead of CR.P. number 111 of 2026. So he seeks leave to correct the same in the court brief. Stop. Prayer is allowed. The necessary corrections shall be carried out by the learned counsel for the petitioner. Which shall bear his initials to be countersigned by the court master. तो बारीक दे देवे करेक्शन है तापर कोन जोटी अपन सर थिला सु नोटिस आलन को दि सर लिखिला Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed
Within 5 days.
within 5 working days. Returnable date be fixed to 27/7/2026. Matters shall be listed for orders in the week commencing 3/8/2026.
I filed IA for
IA 180/2026. Hard Learned Counsel for the petitioner, he reiterates his submissions as noted above. So, issue notice to the opposite party as above, as directed above. Then Sapara accept one set of process fee as well as postal requisites. সেটা ঠিক আছে না ভুল হয়ে যায় সেটা
না না সেটা ঠিক আছে IA ঠিক আছে
except one set of process for postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that CP number 25 of 2026 pending before the Court of Learned Judge Family Court Rayagada shall be adjourned to a date beyond 10/8/2026 as would be convenient to the Learned Court in season of the matter upon a prayer being made for the said purpose. Urgent certificate copy.
State
Yes, next date.
Item 10.
The adjournment order ହେଲା ପରେ
আচ্ছা তারপর লিস্ট আর্জেন্ট
যদি কইবে তাহলে মু স্টে বিলকুল adjournment order ବି দেবিনি.
না না
No stay. The strategy of not frustrating the litigation at trial court is not TRP jurisdiction is not meant for that. In most of the cases are lingering because they are filed here only to frustrate the proceeding. କୋଉ stage ରେ ଅଛି ସେଟା ସେଠି
সেটা হবে নোটিস
ସେଟା
আসছে
କହି ଥକି ଗଲେଣି ଆଉ ପଚାରନି.
ଆଜ୍ଞା
ଆପଣ appear କରିଛନ୍ତି
ଆଜ୍ଞା ମୁଁ appear କରି ଯାଇଛି
କାଉନସିଲିଂ କାଇଁ ଯାଉନାହାନ୍ତି? ହାଇକୋର୍ଟରେ କଣ ହବ କାଉନସିଲିଂ ହେଇପାରିବ? Is there any provision?
there is no मतलब mediation fail କରିବ because his wife is not ready
ଯେମିତି
to
predictive ଯାଆନ୍ତୁନି.
ନା ନା ସେ ମତେ
Being a lawyer, you should not have make the responsible statement of making that mediation fail karibo. Mediation is not contemplated in Family Courts Act or Hindu Marriage Act. Counseling is contemplated in Family Courts Act. It is a mandate of the statute. Hindu Marriage Act makes it mandatory. Family Court counselor kouthi achanti? Where they are? They are only in Family Court,
Family Court,
not in
yeah.
High Court or in other court.
ସେଇଠି
The entire scheme is frustrated in this process. ଆପଣ ପାର୍ଟିସିପେଟ କରିବେନି କାଉନସିଲିଂ କୁ ଯିବେନି ଏଠି ହାଇକୋର୍ଟ ରେ କେସ୍ ଫାଇଲ ହବ ଷ୍ଟେ ହେଇକି ପଡିକି ରହିବ. Your learned brothers are only saying this. ଆଜ୍ଞା 2 ବର୍ଷ ପରେ ବର୍ତ୍ତମାନ କେସ୍ ସେଇ ଷ୍ଟେଜ ରେ ଅଛି. But why then the statute has been made counseling mandatory, cooling off period mandatory? Those things are that it has a purpose. Anyway, and that is the reason the date is not at your convenience, it is convenience of the court. Yes, Mr. Mahapatra.
May I please, Your Lordship? I seek transfer of CP number 28 of 2025, Annex
Yes,
2, filed by husband,
Yes.
but at the jurisdiction of the civil judge senior division.
How many cases you have filed against the husband?
Again,
ଆପଣ କେତେ husband ଙ୍କ ନାଁରେ କେତେଟା କେସ୍ ଫାଇଲ କଲେଣି?
ଦିଟା ଗୋଟେ FIR କରିଛି ଆଉ ଗୋଟେ DVMS case.
Can that be a ground for transferring the case filed by the husband?
The second ground I have taken that financial condition is very distressed, and the third ground is the distance.
Is he receiving any maintenance?
No. And father
take notice the
father is
Mr. Rudananda Mahapatra for the petitioner. Opposite party blank. The petitioner before this court is the wife in the marriage. C6 transfer of CP number 28 of 2025 pending before the learned civil judge into bracket senior division, Banki to the Court of Learned Judge Family Court, Puri. The said CP has been filed by the husband in the marriage under section 13 of the Hindu Marriage Act, 13 into bracket 1, into bracket I-A and I-B, Roman 1, I-small b of the Indian Marriage Act, seeking dissolution of marriage solemnized between the parties on 4/7/2010 and grant of decree of divorce. Stop. All right, it is submitted that the say sethi rochun tankar parental house re.
ତାର ଅଙ୍କଲଙ୍କ ପାଖରେ ରହୁଛନ୍ତି ବାପା ମରିଯାଇଛନ୍ତି
The petitioner after her marriage has gone into rough weather, stays with her paternal uncle and maternal who uncle?
No, uncle, father's brother.
With the paternal uncle at at village Notary, next at Benagaon, at village Benagaon, post Godasahi, PS Konasa in the district of Puri. Dekhi spelling out. Submitted that the petitioner wife is in distress as she is not being maintained by the husband, and she has filed application under the Domestic Violence Act.
Minor. Section 12 of the Protection of Women.
12 of the DV Act,
Minor.
seeking financial assistance, which is pending before the Lord Judge,
JMFC Konasi.
Lord JMFC Konasa in the district of Puri. They submitted that the petitioner finds it difficult to attend the matter at Banki in the district of Cuttack. Stop. Then issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed
Within 5 working days.
Within 5 working days. Returnable date be fixed to 27/7/2026. The matter shall be listed for orders in the week commencing 3/8/2026. IA 188 of 2026. Hard-hearted counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above. Issue notice to the opposite party as directed above. Requisites, the requisites to accept one set of process fee as well as postal requisites. Returnable date as well as the next date of listing shall be as directed above. Stop. In the interim, it is directed that CP number 28 of 2025, pending before the Lorded Civil Judge into bracket Senior Division, Banki, shall be adjourned to a date beyond 10/8/2026 as would be convenient to the Lorded Court in season of the matter. Urgent fact find coordinated be issued as follows.
Diplomat.
Yes, next please.
11. May I please receive?
So, you are Mr. Chotra. So, Rituranjan Chotra for the petitioner. So, what is that record? कौन सेटा कहले विटर
the copy I have solved.
कोर्ट रे फाइल करिवे ना बरे काचा पाचा भांगियो पड़ियो एटी से फैसिलिटी नहीं.
Only, let's say, the present petitioner is the wife of the opposite party, challenge the order P1 2026, thereby rejecting the prayer for calling from the documents, Lordship. Only small prayer, Lordship.
को स्टेज रे डॉक्यूमेंट मागिले
Lordship, page
डॉक्यूमेंट
26.
मागिवार ज्ञानोदयटा को स्टेज रे हेला
Just after the examination of opposite party.
को प्रोविजन रे अछि
Opposite.
आफ्टर एग्जामिनेशन परे कागज मागिबे को सीपीसी रो को प्रोविजन रे अछि.
Lordship, on 21.
अरे लॉर्डशिप ऑन 21
21 रे हेला में 22 रे मागी.
Sir, let us not spend time like this. Already we are stressed for trying. Still we are able to manage. The question is pointed and specific. Under which provision of CPC you have called for documents after examination of the you cross-examined.
No, during process of cross examination, not completely.
During cross-examination, ଆପଣ document ମାଗିବେ କୋଉ provision ରେ? ମୁଁ ତ ଆଜ୍ଞା ଏଠି ତ see I have to be I have to understand and implement follow law.
Yes, yes.
Same is with you. So you have to assist me, educate me. So do that. Just before my lord,
order 16 rules.
ମୁଁ ଯଦି ସେଟା ଲେଖିବି ତାହେଲେ କଣ order ର କିଛି sense ବାହାରିବ?
Order 16 rules 6 ରେ
ଦେଖନ୍ତୁ ପଢନ୍ତୁ sir. Don't give a speech. 16:6 ରେ ଆପଣ ମାଗି ପାରିବେ ଯୋଉଟା ଅଛି ପଢନ୍ତୁ। ବହି ନାହିଁ କହିବେ ନା ମୁଁ ବହି ଧରିଛି ଆପଣ ବହି ଆଣିନାହାନ୍ତି ବୋଲି କହିବେ। ଆପଣ ସିପିନେ ସେ ମୋଟା ବହି ମୁଁ ଉଠେଇ ପାରିବି ବହି ସେଟା ରଖିଦେବି ବହି ଉଠା ନିଶ୍ଚୟ। ଆପଣ ଏଠି ମୋଟା ବହି ଆଣି ଗଦାନ୍ତୁନି ଆଜ୍ଞା। difficulty as such ମାନେ ସ୍ପ୍ରେ ନେଇକି ଯେତେ ମୋଟା ବହି ସବୁ କାଢନ୍ତୁ। ଆଉ ଯୋଉଟା ତ ସବଷ୍ଟିଚ୍ୟୁଟ ନାହିଁ ଆପଣ ସେଇଟା ବଦଲେ ମୋଟା ଆଉ ନାହିଁ ଆଉ ବହି ନାହିଁ।
summons to produce documents. Rule 6 or order 16 rule 6.
ପଢୁନାହାନ୍ତି
Any person may be summoned.
କଣ ପଢୁଛନ୍ତି ସାର୍? ଆରମ୍ଭରୁ ପଢିବେ ସବୁବେଳେ। Blunder to read from ଗୋଟେ provision ମଝିରୁ ପଢିବା ଆରମ୍ଭ କରିବେ।
Summoning and attendance of witnesses.
List of witnesses.
List of witnesses and summons to witnesses.
Yes.
And 2 is expenses of witnesses to be paid into the court.
What you are reading?
That's it. Just I am reading. I am trying to read the particular. Sorry. On or before such dates as the court may appoint, and not later than 15 days after the date on which the issues are settled, the parties shall present in court a list of witnesses whom they propose to call, either to give evidence or to produce documents, and obtain summons to such persons for their attendance in court.
ତୁ ପଢନ୍ତୁ ଅଟକିଲେ କଣ ମୁଁ ସବୁଥର ଗୋଟେ ପ୍ରପ୍ ଦଉଛି ପଢନ୍ତୁ।
A party desirous to obtain any summons for the attendance of any person shall file in court an application stating therein the purpose for which the witness is proposed to be summoned. 3. The court may, for reasons to recorded, permit a party to call, whether by summoning through court or otherwise, any witnesses other than those whose names appear in the list referred to in sub rule 1, if such party shows sufficient cause for the omission to mention the name of such witness in the said list. 4. Subject to the provision of sub rule 2, summons referred to in this rule may be obtained by the parties on an application to the court or to such officer as may be appointed.
ଆପଣ କୋଉଟା ରିଲାଇ କରୁଛନ୍ତି ସାର୍?
6ଟା order 6ଟା only summons to produce documents. May read. Any person may be summoned to produce a document without being summoned to give evidence, and any person summoned merely to produce the document shall be deemed to have complied with the summons if he causes such document to produced instead of
6 ରେ ଆପଣ ମାନେ production ପାଇଁ ମାଗିଛନ୍ତି ନା document ମାଗିଛନ୍ତି?
production of the documents.
କାହାକୁ ଡାକିଛନ୍ତି?
opposite party.
Sir, answer କରନ୍ତୁ। This is not a place for ଗୋଳା ଗୋଳି କରିବା। ଆପଣ ଯୋଉ application prayer ଦେଖାନ୍ତୁ।
To the court to produce before
prayer ଦେଖାନ୍ତୁ application ଯୋଉଟା କୋର୍ଟ ରେ ଫାଇଲ କରିଛନ୍ତି।
Annexure 3 page 28. Let's say I have annexed.
Prayer
part is page 30. Page 30. Let's say. Page 30.
schedule kain eta ki produce kariyo
That the documents is availed before the
6 is not applicable.
let's see documents
Lordship.
6 is
6 रे कोन पढिला उतारे ये छोटा है, we have been vast and the proceeding is recorded. You must understand. And children are coming here to study and read law. Just take care of that. You don't come with book. Don't answer queries. Do not understand what you have prayed and what is the prayer before the trial court. How order XB, that is 16 will help you. Who will produce? मते अनले कोन हो सर
the author
पढिबे ना
let's see the authority where the
सेटा
office
मते कोठी सेटा प्रेयर रे कोठी अछि आपण प्रेयर ता देखिले पेज 31 रे शेड्यूल देखिले लुकेड एले मन जदि न पढिबे मते कहबे न मु पढी because our discussion we are just spending time like this. Any letter filed by Manasi Lenka so and so against her husband from the office of the superintendent of police Hon'Ble की सेट कर ताकू आपण एबे मगेबे
let's see that opposite party is
देखेले इनिशियल लिस्ट देखेबे इनिशियल लिस्ट देखेबे ठीक
insert the annexure let's say page 34 lost
एनी लेटर आपण लेटर स्पेसिफाई भी करिवेनी
lost he has
एटा कोन चलची कोन आगे सेटा ट्रायल होची ना एठी कोन माने
let's see just
सब कथा त आपण लॉर्डशिप कहउछथि मु भी आपण
page 26 can be received
26 रे कोन मागितले
sorry page 26 no page 23
कोन मागितले
page 23 para 40 the
अरे क्रॉस एग्जामिनेशन पर कथा पड़े आपण को ओरिजिनल शेड्यूल जोडा आपण को ऑर्डर 16 रूल 1 ने जोडा फाइल करथिले लिस्ट देखंतु
मैं से
अरे सीए कोन तो आपण बसी जानतो ऑलरेडी
page 31 हजुर page 31
रे ता भीतर पढु थांतो
page 31 शेड्यूल page 31 रे शेड्यूल
बसु ना मिस्टर काई व्यस्त होचंती कहिबे अरे सर इज इट दैट आई एम नॉट अलाउ यू 31 नो आ गया आपण ऑर्डर 16 और रूल 1 रे जोटा लिस्ट देथिले 31 रे आपण सडनली आपणकर ज्ञानोदय हैला क्रॉस एग्जामिन करके डॉक्यूमेंट मागिले that you should avoid also. You must understand that you should confine your argument at the cross examination on the existing documents.
that documents
pleading रे कोठी अछि लेटर
no that documents is not
still worse आपण
not available in the court
आपण pleading रे कोठी लिखि चंदी जे से क्रॉस एग्जामिन चिट्ठी लिखतले देखन
let's say amo pleading they have filed petition
उणी बनी तो लॉर्डशिप आमो pleading हो आपणकर जोथिरे जो बेसिस रे मागिबे डॉक्यूमेंट ता किछ अछि एसडीपीओ और एसपी को जो चिट्ठी मागुचंती से पर नॉन स्पेसिफिक लेटर रिटन में मानस लेंका कॉन्स्टिट्यूशन ऑफ इंडिया
no
आपणकर जो चिट्ठी कथा कोछन आपण जान नाहंती से चिट्ठीटा लिखिचंती बोली कोठी प्लीडिंग्स रे अछि कि देखन
I have not referred any letter. It is my case, Lordship.
So I'll record that.
No, Manasi Lenka has never, Lordship, just a minute. Manasi Lenka.
Just a minute, कोई समय नष्ट करंतु आपण तो निजे बुझी पर नांती पढु नांती मु पढिबी बुझेई पिटिशन के फाइल करछन
petition opposite party
फाइल करले सेटा अलाउ होला ये होला
नहीं at the cross examination they have given his evidence on that evidence there are trial
कहबा आरंभ करले सर गोटे कथाटा आंसर देला परे तापरे कहंतु केते थरा गोटे कथा रिपीट करबी ए जो एप्लीकेशन ता जोडा फाइल हेची ए जो प्रेयरटा प्रोडक्शन एटा रिजेक्ट होला ना अलाउ होला रिजेक्ट होला ताकू चैलेंज के करछन
I have challenged
आपण ताले आपण के कहछन सी फाइल करछन
he has filed this
मानसी लेकर आपण कहा वकील
Manasi Lenka
सो मानसी लेंकार जो वकील आपण मानसी लेंकार को प्लीडिंग्स रे देखांतु आपण किछि लेटर को रेफर करिसंती कि कितने समय
page 31 रे मेंशन
31 आपण बुझी परनांती 31 इज पार्ट ऑफ
that petition Lordship
मु पिटिशन पचले आपण को
से पिटिशन से मानस
तो आपण को मु देखैली आपण जो प्लीडिंग्स रे जदी किछि सब्सटेंशिएट करिया को चाहउचंती आपण से ट्रायल कोर्ट रे कोन आपण मानस लेंगा किए
हम अपोजिट पार्टी
सो रिटन स्टेटमेंट देखांतु
लेट्स सी
रिटन स्टेटमेंट को प्लीडिंग्स को आ जाए
रिटन स्टेटमेंट रे सेमान
नहीं छाडंतु सर नो
लेट्स सी दे हैव नॉट गिवन दे हैव नॉट
अरे दे छाडंतु आपण जोटा मागुचंती यू फील रिक्वायर्ड टू प्रोड्यूस ए डॉक्यूमेंट
at the time of lords at the time of evidence this
sixth applicable no sixth applicable no at the time of evidence you cannot कौन हेतले हितांदा सिक्स एप्लीकेबल क्वेश्चन सुनिबे उत्तर देबे आपण जेटा सिक्स आउथरे देखो बोलो summons to produce document first of all that is not applicable so आपण पे best case scenario होबो is it a non obstante clause notwithstanding anything contained in anywhere or non anything above it ता भी no so how six will help you so 6 has to be read with 1 the person the documents which you are seeking in order 16 rule 1 the person has to be summoned and that is how he cannot say that I will not come to the dock so order 16 rule 6 to my understanding and I think it is correct also can only be utilized as far as list to one re jota apun one author dekho list of witnesses and summons to witnesses so this SDPO or officer or the superintendent of police cannot say that I have nothing it is a fight between Manasi versus Sanjay because court has power to summons by 6 आपण 6 टा को बडे जगह रे यूज करछन जदि आपण किछ एप्लीकेबिलिटी नाही and to assist you only because this discussion only that because since you are unable to make out any case so I am trying to understand whether any case can be made out to assist you only I am asking you whether you have referred to any such document ठीक है yes yes take your seat Mr. Chot
they have filed another writ application number 1545
आपण एतरे कन्फाइन करू सर आपण ए जो डिस्कशन चाली छि एते समय में नेलेडी आपण मानू बही जोगाडी दिया गला आपण
this she has not mentioned the letter number nothing
ते तो मु भी कहसले
that
मु बुझी पारि थांती मु बुझी पारलेन बोले तो पचारली
से किछि देना से देबे
लेटर अछि
सर सेटर भी किछि ये लेटर किछि वैलिड नाही किछि रिलेवेंस नाही ये केस संगे कारण आमे कहलु आमे सबुटे केस करछ हमने 20 टा केस मोनारे करछ तनु से 20 टा आगे सबुटे 18 टा 16 टा रजिस्टर्ड हेछि एफआईआर हेछि जोटा सेटा मगु नांती जोटा एफआईआर हेलानी जोटा रजिस्टर्ड हेलानी सेटा मागुसंती फिर जोटा डॉक्यूमेंट नथो सेटा डस्टबिन जाय तो सेटा कहते हमकु दियो व्हाट इज द रिलेवेंस ऑफ दैट डॉक्यूमेंट
डस्टबिन कॉल लेबे ऑर्डर 16 रूल 6 कोन की
नहीं
जदि ताकर फीडिंग थिबो दैट लेटर हैज बीन पुट टू डस्टबिन केप नियर से जे मिस्टर बारी को डस्टबिन दोचंती ताको डाकिबे हाउसकीपिंग मना करि परिबो ना आगे मु जिबिनी मानसी रो आगे मु डस्टबिन उठेला so that is how order 16 rule 6 empowers the court to summon anyone
yes but it does not
नकरे से कहबे जागे डस्टबिन ने सेमती नथिला पेपर पड़ी नथिला
no it does not mean that bluntly they have said that is the letter
डस्टबिन ने पड़ी
नहीं
डस्टबिन को डाकी हबो
डाकी हबो माने जे ब्लॉन्टली लेखि
मैं देखितले कम तारीख डस्टबिन ने पड़ीतला से कहबे आगे मु देखते तो पके दिल बाहर नहीं पके दिल
नहीं
I mean possibly that is how it is interesting
my lord I may permit
नहीं आपण सुनंतु being officer of the court मुझा पचारछि may not be in your favor बा सेरे भाबिबेनी is there anything referring to any letter जोटा से कहि पर नांती
नहीं nothing
किछि नहीं
ना
sure confident आपण confident
there is no reference
it may go against you but you should tell that truth
no my lord there is no reference at all ye they compel to the petitioner that you have filed a complaint against you my client has filed a complaint against you admitted basing upon that statement they have said that my client has given a statement and that will call for and above all
in fact I have discussed with Mr. Chotra
they have
earlier should not have weakened your case by making such statement because if you are relying on any already एटा आपनकर अपोजिट पार्टी कान आपनकर जो 13-1 क्रुएलिटी रे फाइल हिच ना कोन
हां क्रुएलिटी तेरे
सो अगे 13-1 क्रुएलिटी रे आपन जेतोडे 10 टा लेटर लिखि चंती 26 टा केस करि चंती ये की स्ट्रेटजी कोन आपण लॉ बुझिले जे ताकू मागिले जे
Selection all those allegation letters would be in custody of the concerned department.
सेते कुए
Se- ମାନେ ତାଙ୍କ evidence ରେ ଆଜ୍ଞା ସବୁ ଅଛି ଜିନିଷ।
आपण जहा कहले नी आपण को धरा पृष्ठ रे आज्ञा सब किछि अछि
ଆମେ
ତାଙ୍କ evidence ରେ ଆଜ୍ଞା ସବୁ ଅଛି ଏଇଟା ଏଇଠି ଅଛି ସେଇଠି ଅଛି।
ଏସପି ଅଫିସରେ କୋଉଠି ଅଛି ଆମେ
स्पेसिफिक आपण केते इलाबोरेट प्रोविजन देखंतु जे करिसंदी 1908 मसिया ने केतବେଳେ हेतला से हाउ इलाबोरेटली दे हैव माने प्रोजेक्टेड डिस्कस्ड द लॉ आमे मते तो लागुन मु तो एटलिस्ट कर पार न था आपण जो प्रोविजन रे रिलाय करछन जेटा किछ रिलेवेंस नै इट हैज टू बी वन समन्स टू बी इशूड इन 16/6
Lord,
See with
the
the question
sole
देखिए आपण
intention of them
आपणकर अच्छा now Mr.
Yes, sir.
it is academic discussion now nothing to do with the case let us assume there is some letter
Yes.
that is produced let us assume that what is the what turns on that
On that
ଆପଣ
letter,
କଣ କରିବେ? What
on
is
that
your
letter, it
strategy?
is proved that I have made cruelty on my husband. If that letter is found, then cruelty is proved that I have.
ଆପଣ ପରା କହୁଛନ୍ତି ଆପଣ ପିଟିସନ ଫାଇଲ କରିଥିଲେ
ନା petition ସେ file କରିଛି ନା petition ନା
petition,
ହଉଛି
I am the
ସେ file
ନାଇଁ,
କରିଛି।
ଯୋଉ ଆପଣଙ୍କର ସେଟା ରିଜେକ୍ଟ ହେଲା ପରେ ଆପଣ କାଇଁ ତାହେଲେ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ତାଙ୍କ ପିଟିସନ ସେଟା ଷ୍ଟିଲ ଦେନ୍ देयर इज ए कन्फ्यूजन
हजुर ତାଙ୍କ petition
सर सीए फाइल कले रेकर्ड प्रोडक्शन ପାଇଁ
ନା
ନାଇଁ ସିଏ ଫାଇଲ କଲେ
ଆମେ ଫାଇଲ କଲୁ
ଏବେ
record
ଏବେ କହିଲେ ଯେ सीए फाइल କରୁଛନ୍ତି
ସିଏ
ବର୍ତ୍ତମାନ
ଫାଇଲ
କହିଲେ
କରିଛନ୍ତି ସିଏ divorce ପାଇଁ ଫାଇଲ କଲେ
ଛାଡ଼ନ୍ତୁ sir।
cruelty count ରେ
ଆପଣଙ୍କର କଲିଂ ଫର ଯୋଉ କହୁଛନ୍ତି ଅର୍ଡର 16
ହେଟା ହେଟା ମୁଁ ଫାଇଲ କଲି।
ହଁ ହେଲା ଆପଣ ଚାହୁଁଛନ୍ତି ଆଉ ଥରେ 31 ପଢନ୍ତୁ one step ahead these two step backward 31 again ପଢିବେ शेड्यूल ଟା पढନ୍ତୁ
Let's see. Any letter filed by Manasi Lenka, wife of Sanjay Kumar Lenka, against her husband,
सेटा एड्रेस फोन नंबर
Yes, sir.
पढिके तापरे
who is working as
ऑफिस
ASI.
ऑफ द सुपरिटेंडेंट ऑफ पुलिस संबलपुर
Yes,
ऑफिस
sir.
ऑफ द एसडीपीओ बुर्ला
Yes, sir.
सो एटा आपण फाइल कले नाउ दिस लेटर्स अस्यूम अछि कि नै त आपण लिखिना निजे जानिना let us assume that letter written to by Manasi Lenka to the superintendent of SDPO is produced.
Yes.
What turns on that?
Only that that I have cruelty on my husband.
तो आपण against आपण evidence.
Yes, yes. If I have not given any documents,
सेमिति कोन
Sir, for that reason,
जानिनी
no documents will you will not see no.
ट्रायल अभिज्ञता नाही कि जेति कि अछि what is going on आपण कोन आपण तो डिनाय करिवे सिंपली
Yeah, the documents किछि मिछर से किछि पाइबे
यदि मिछ करे तो पचारिवे सरला आपण तो क्रॉस एग्जामिनेशन करना हंती कि
क्रॉस एग्जामिनेशन से क्वेश्चन
आपण निजर एग्जामिनेशन चीफ देइछंती आपण सइलेन एग्जामिनेशन इन चीफ
आज्ञा
कोन कहिसंती आपण लेटर विषय
हम देइनु किछि करनु
सरला what is this going on
But-
rather the court has saved you शुणु आपणकर आपण बर्तमान शेड्यूल ले पढिले in fact that creates lot of confusion आपण निजे आपण अगेंस्ट एविडेंस खुचछंती
नहीं सेमति नाही किछि बोली
सर आपण सब
Yes,
बेले
yes, yes.
when he has filed the case the onus and burden of proof is on him
Yes, sir.
but you have sought for a letter which you have written against the SDPO so against your husband to the SDPO and SP
Yes.
why should you in fact I am so confused by this
Your lordship may dispose with that observation. Your lordship may dispose with that.
observation मु कहि देबे मु कोइ ट्रायल करछि मु तो बुझी पाउनी आगा सेति पे I have ensured that this petition is filed by you आपण कहा वकील मु पचर कारण सेटा because the schedule discloses you are seeking a copy of letter
Yes.
which you have written
Yes.
to the SDPO and SP against your the husband so what is the relevance सीए जदि किछि लेटर प्रोड्यूस करछंती मेंटल क्रुएलिटी आपण देखौछंती मो नारे से सबले पिटिशन पकांती या तो आपण
Yes, yes. They have to produce your lordship. They have to produce your lordship.
ये
But-
प्रोड्यूस करिवे से प्रूव करिवे आपण कहे मु एटा लिखिनी possible
Yes, yes, yes. Lord.
So I
They have
don't know
not.
what is going on
Let's see on that observation.
also both of you kindly take your seat that doubt of मु पचारी लेकिन आइटम केते the matter is listed for fresh admission आगे लिखिवे एटा आपनकर कोन नोटिस इशू हिनी आपण अपियर करछंती
Yes, last occasion it was listed before the vacation bench, and above all, this matter was disposed by your lordships. thereafter they have filed a second writ application. This is the order of your lordship. Have a glance. ଗୋଟେ
ନାଇଁ ସେଇଟା ଏତେ ମନେ ଅଛି ଆପଣ both of you use ଆପଣ ଯୋଉ ତିଳକ ଲଗାନ୍ତିନି କି ସେ ଛୋଟ ରାୟଙ୍କର ଇଏଟା ମୋର ମନେ ଅଛି। So
that was
now the cat has come out of the bag. ମତେ ଲାଗିଲା ଆଗରୁ ଏଇଟା ଏମିତି ଗୋଟେ
ନା ନା
ହେଇଥିଲା।
ସେଟା ସେଟା ସାଇଡ ହେଇଯାଇଥିଲା
ସାର୍ ସେଇ ଅର୍ଡରଟା ପୁଣି ଆଉଥରେ
So now Tilak is powerful or Tika is powerful.
that seta side we have challenged that seta side this is the consider the documents
এইটা দেখନ୍ତୁ ପ୍ରେୟାର ଲେଖିଛନ୍ତି ସେଟା ସେଠି ଅର୍ଡର
consider
ପୁଣି ସେଇଟା ଯୋଉ ଅର୍ଡରଟା ସେଟା ସେ ପକେଇଥିଲେ ସେଇଟା ରିଜେକ୍ଟ ହେଲା ପୁଣି ଆଉଥରେ ଫାଇଲ କରିଛନ୍ତି।
this is the
ପ୍ରଡକ୍ସନ ତ
production of the
ଡକୁମେଣ୍ଟ ସିନୋପସିସ୍ ଦେଖୁନ ଆଉ କଣ
prayer ଦେଖ
ପ୍ରେୟାର ଦେଖୁନ ପ୍ରେୟାର the sole object of my friend is to linger the matter.
No, no.
Nothing.
ସେଇଟା legitimate strategy. ଏଇଟା ତାପରେ ଆପଣ ବ୍ଲେମ କରିବେ କୋର୍ଟ କିଛି କରୁନାହାନ୍ତି ଏଟା ପେଣ୍ଡିଂ ରହିଲା। ଆଜ୍ଞା ସବୁ ଯାକ TRPC
କାଲି କି ଅଛି ସାର୍ ଆର୍ଗୁମେଣ୍ଟ ପାଇଁ କାଲି କି ଅଛି your lordship specifically direct one chance should be given, that is 25th. When the matter is posted to 25th, they have filed another writ petition.
no only I have
Only
call for the documents
Sir,
give
at least the
documents
at least without looking at this order also I'm disposing it off obviously. So Ritu Ranjan Chotray for the petitioner, Mr. Ellen Patnaik for the opposite party. The matter is listed for fresh admission as it was moved before the learned as it was moved before the matter is listed for fresh admission. Now has no having earlier been moved before the vacation bench, before the coordinate vacation bench. The vacation, the coordinate bench, the coordinate vacation bench, considering the submissions of the Lorded Counsel for the petitioner as well as the opposite party, Lorded Counsel plural, counsel is plural. By order dated 19/6/2026 has directed the matter to be listed before the assent bench, and accordingly the matter is listed today. Having heard the learned counsel for the petitioner at extensively, as well as the learned counsel for the opposite party at some length, the petition is finally disposed of, considering the fact that keeping the matter pending before this court is not in the interest of both the parties to the litigation. The petitioner in the present writ application filed under Articles 226 and 227 of the Constitution of India challenges the order dated 03.01.2026 and dated 29/2026. Mr. Patnaik, ये ऑर्डर उड़ा कागुरु चे सब्जेक्ट मैटर इतने थी लगी
पढ़न
जो 3/1/26
हाँ सर 29/26 रे ऑर्डर थिला
इतने
से हाँ 29/26 रे सेटा ये थिला वर्तमान प्रोडक्शन ऑफ डॉक्यूमेंट एटा हमको नाही करते रिजेक्शन करथिले बोल सेटा थिला
in the prayer only 3/1/26 lordship only 3/1/26
आज्ञा आपण जेमति वाले केस कोठी कोन लेखल तार ठिकाना
ना prayer your lordship in the vacation
आपण कॉस्ट टाइटल लाइक वेरी इंपोर्टेंट कॉस्ट टाइटल आपण 29 लिखिछन
no vacation judge it is specific she has specifically
जज कोन सच
नहीं,
रीडिंग टाइम
specifically
लिखले
reflected-
वेकेशन जज
basically लिखी दी
सर देखना लिस्ट ऑफ इवेंट्स यस
ना prayer
सेटा सेड पिटिशन आल्सो कॉल फॉर द विटनेस एडिशनल एविडेंस रिजेक्टेड 29/26 सेटा भी मागिसन से
चैलेंज द और देखो तू 3/1/26 as mentioned in the prayer of the petition passed by the Lorded Judge Family Court Bhubaneswar in CP number 23 of 2019 देखो आज ऑर्डर कर दे अपलोड भी करते You kindly take your seat, both of you. Doubt hele pachari. By the said order dated 3/1/2026. The petition filed by the co-line रे सेटा अच्छे हैं आपन petition टा जो छोटा है और जो 3/1/26 ऑर्डर टा कोच
Okay, let's see.
पेज
Let's see.
पेज
Page, let's see, 34, let's see. Page 34.
फाइल नहीं खोजी
34.
कौन लिख ले by the present petitioner who is the opposite party in the CP before the learned judge family court. Sentence आंसर पढ़ो तो petition filed by एते so and so dated 20/11/2025 family court purportedly under order 16 XVI rule 6 seeking documents has been rejected. ठीक है तो मिस्टर छोटरा The petition has been annexed to the writ application marked as annexer
4 series.
4 series no आया
Petition टा annexer 3.
3 आया
Petition annexer 3.
The petition has been filed. Copy of the petition, no? Copy of the petition has been annexed to the writ application marked as annexer 3. Stop. The prayer made in the petition as well as the schedule is reproduced herein. Right, marginal लिखिए page 30 रे prayer अच्छी. It is therefore prayed that your honor up to neki shall ever pray. Shall be scheduled quotation रहेगा schedule dash A underline है ला तापर any letter filed by up to Purla reproduced here ने एटी produce कर दे page 30-31 तक. The learned judge family court has considered the submissions of the present petitioner as opposite party as well as the petitioner as present opposite party and passed the following orders. Following order dated 03.01.2026 देखिए page 35 रे पाइबे. देखिए 35 रे अछि the petitioner filed the case on the ground of cruelty हैला सेठु नै कि further cross examination of PW1 as the petitioner relies on the provisions contained in order 16 rule 6. The said provision is reproduced herein for convenience of reference. Order 6, order 16, summoning and attendance of witnesses, rule 1. Rule 1 just quote hela list of witnesses to neki attendance in court. Tapare 1, 2, 3-4. Then rest गुड़ाक छाड़ी देते straight away root 6. 6 and 7. Did I miss it? 6, 7. Having perused the application filed by the present petitioner, who is the opposite party, as reproduced herein, as reproduced above, particularly in the schedule, schedule indicating the document sought for. This court finds that the reasoning given by the learned judge family court denying the prayer is just and proper. On being asked, the learned counsel for the petitioner submits that he has not instructed with the list of witnesses and summons to list of witnesses and the documents that was filed before. That was filed in accordance with Order 16, Rule 1. Stop. It is for the found that it is for the found लेखन तो अपन तो सेटा written statement टा दे ना थी बोले अपन तो दे ना थी written statement नहीं record रे written statement कौची क्या दे रे annexure ही ची की
ना सिए दे ना
तो it is found लेखन तो change कर दियो तो सब पारा कर लेखन तो on the learned counsel for the petitioner as well as the learned counsel for the opposite party were also apprised if any statement has been made or any reference has been made to the documents as sought for. Both the learned counsel fairly submit that, submit that as per their instruction, the document as indicated in the schedule of the petition dated kete oda 25 kete oda achi 20/11/2025 has not been referred to either by the petitioner before the learned family court or the opposite party before the learned family court. Accordingly, this court does not find any illegality or infirmity in the order dated 3/1/2026. The petition being devoid of merit, the writ application being devoid of any merit is dismissed as the learned counsel for the opposite party produces copy of the order dated 22/5/2026 passed by this bench in WPC number 1543453 of 2026. Vacation judge रे कोंका पाखरी बेटा अपन प्रोड्यूस करले ना एटा प्रोड्यूस करले
नहीं एटा
कॉपी ऑफ द देखिए उसी 15,453 of 2026. He submits that earlier another writ application was filed which has been disposed of by this court with the following observations. Para 345. Quote कर देंगे. The copy of the state order is kept in the present brief. In view of the above, apart from disposing of the dismissing the writ application, it is directed that the learned judge family court shall proceed in adjudicating the matter in accordance with law, as has been already directed by earlier order dated passed in WPC. Yes. Yes. Anything else, Mr. Anything else, Mr. Chotray? Patnaik?
Yes.
Cooperate करंतु आज्ञा एटा this strategy doesn't help. आपण जदि सेटा at least conclude हबो आपण को फेवर रे गला से चैलेंज करिवे ताको फेवर रे गला आपण चैलेंज करिवे बट आपण ए जो सेठी प्रोलॉन्ग डे there is a direction statutory limitation जे आपण जल्दी dispose of हवा कथा हो. Rest of the matters after recess, any mention?
Achora item 2.
My lord, part. Mention my lord. Item 28, my lord. Notice has been sought that it was undelivered due to insufficient address, my lord.
So try to find out present correct address. कितने दिन नेबे?
7 days, my lord.
2
Permanent
weeks
address.
दियंतु. So that बारंबार लिस्ट କରିବାକୁ पड़िबनी. ଆପଣଙ୍କ ନାଁ ସାର୍?
R. Naik, Hospital John Naik.
28 ଟା returnable date କେବେ? 2 weeks ପରେ ଦେବେ ହେଲା.
27.
ତାପରେ 2 weeks ଦେବେ. Distal 18 निश्चित वीक कमेंट 17 को ठीक है यस
परमानेंट एड्रेस ଦେଇଥିଲେ ସେଇ ଆଡ୍ରେସ ରେ ପ୍ରେଜେଣ୍ଟ ଦେଇଥିଲେ ପରମାନେଣ୍ଟ ଦେଇଥିଲେ ଆମେ ପ୍ରେଜେଣ୍ଟ ଆଡ୍ରେସ ରେ ଫାଇଲ କରୁଛୁ ସେଟା ପାଇନାନ୍ତି ପରମାନେଣ୍ଟ
ସେଇଟା ତ ନା ଟେକ୍ନିକାଲ ପ୍ରିଭ୍ୟୁ ଟେକ୍ ମୁଁ ଜାଣିନି ଆପଣ କଣ ଷ୍ଟାର୍ଟ ଯେ ମୋଟା ଭଇ ସବୁ କାଢି ପକେଇଲେ ଉଠାନ୍ତୁ ପରେ ଠିକ ଅଛି କୋର୍ଟ ସରିଲା ପରେ କାଢିବେ ବସନ୍ତୁ ଆପଣ you try to solve in the present correct address ହେଲା sufficient time that is the reason you are being given sufficient time non-appeals for the petitioner though the matter is called twice over once when it reached and again after resumption of the proceeding post lunch to grant further opportunity to the petitioner list in the week commencing Tiniat इतने फ्रेश एडमिशन कोड 3 आटे लगौछन्ते आपण
ये वीक रे
आपको बुझे हबनी बहुत कष्ट आपण 2 नंबर आइटम कहउछन्ती त आपण आज होची जून 23 आपण 8 अगस्त रे लगेलेनी मैटर 3 अगस्त फ्रेश एडमिशन जदी एप्टी करबे केमती हबो 20 in the week commencing 20 but 6 7 13 7 रे लगे करिए week commencing 6 7
Achora item 5.
same order 6 7 yes sir quick
Item 12.
Mr. GB Polda on behalf of Bamadev Varala for the petitioner. The learned counsel for the petitioner seeks for the time to remove the defects as pointed by the SR. Time as paid for is reluctantly granted as the matter is kept pending since 2022. The matter shall be listed for orders in the week commencing 13/7. Defects be removed in the meantime. Yes, next.
13.
13. Mr. A. Mohanty for the petition. For the petitioner. Opposite party, the Anshuman City. Mr. D. N. Lenka, AGA for the opposite party.
My lord, here my
ଆପଣ भी कौन defect remove करे पे कितने दिन नेबे?
my lord, defect is of 2 defects are there, my lord.
2 था कि 2.5 था but अपन
Within-
कितने दिन नेबे?
Within a week, my lord.
Same order 13 ଆପଣ remove କରନ୍ତୁ if you are able to remove early then the removal भी करि परिबे
My lord.
हैला same order 12,013 से
14.
None appears for the petitioner though the matter is listed for orders to grant further opportunity list in the week commencing
6
6 7 20 26
15.
थोड़ा ने चेंज करना आसुनाहांती 14 टा आउथले लिखंतो None appears for the petitioner when the matter is called. The matter is listed for orders with the office note put up by the registry that nomenclature of the matter, nomenclature of the case Maybe CRL MP. CRL MP टा within court what देखिए लिख रहे हैं, no steps have yet been taken though the matter is pending since 2022. The matter shall be listed for orders in the week commencing 6/7/2026, indicating that the matter shall be disposed of. Copy of this order shall be communicated to the learned counsel for the petitioner by the registry. So change कर लिखो तो registry shall communicate this copy of this order to the learned counsel for the petitioner. Yes.
15.
Same. 15 में लिखिए non appears लिखिए defect number 9 has not been removed. See same 6/7
16.
Mr. S.K. Pradhan. 16 टा आपण से सेम आज 12 13 जाए 13/7 जाए टाइम दियो मिस्टर प्रधान. Yes. हां 12 13 non appearance छोड़ा को 14 15 हां आगे 17 सेम आज
17 में please petitioner.
I'm really pleased.
Defect
But
will
really
be
unhappy that after 4 years you are yet to file the certified copy.
beg pardon.
Why should you be pardoned, sir? I don't understand. Or you should also be pleased and to file the certified copy, or you will not file.
By tomorrow.
And the blame is on the judiciary that the matters are kept pending. Have you ever seen any court granting any adjournment on its own? But last 4:30, 4:15 रे को हमें matter उड़ा का. Anyway, same order as in. এটা କେତେ ନବ ଆପଣଙ୍କ ନାଁ
17 पंकज कुमार साहू पीके साहू
ଆପଣ ତ ପାୱାର ବି ଅଛି
लर्सी
ଆପଣ ତ ପାୱାରଲେସ୍ ନୁହନ୍ତି ସକାଳେ ଜଣ କହିଲେ ମୁଁ ପାୱାରଲେସ୍ ମୋର ପାୱାର ନାହିଁ ବୋଲି କହିଲେ ପିକେ ସାହୁ ଫର ଦ ପିଟିସନର ତେମାଜ 12
लिस्ट
18.
प्लीज रिमूव द डिफेक्ट बिना सर्टिफाइड कॉपी रे केस हेई परिबन
लर्सी
आ ଗୋଟେ प्रॉब्लम होची द लिमिटेशन रन्स ଆପଣଙ୍କ ଲିମିଟେସନ ଯଦି ସେତେବେଳେ ନଥିଲା ବର୍ତ୍ତମାନ 4 years added that you have to explain. Lordship କିଛି କରିପାରିବେନି ସେଥିରେ.
Please, your lordship, delay is for 16 days, lordship.
Are you on merits, madam? You do not have power here. Kind?
On behalf of Amita Tripathi,
You are Mrs. Patnaik.
Saubhagya Lakshmi Patnaik.
Mrs. Saubhagya Lakshmi Patnaik on behalf of Amitabh Tripathi for the petitioner.
Delay is for 16 days.
That you have said, I have understood, I have answered that you argue on merits. Unless you make out a case on both the grounds, on merits as well as delay, I will not condone the delay, I will dismiss the writ of petition.
Lordship, notice ta jao delay.
Notice ता जिबा पे कोर्ट हेनी. कोर्ट हेची लॉ अप्लाई करिया पे. Notice दियो को प्रोविजन.
Delay condemnation others.
प्रोविजन कौन जे फाइल करियो नोटिस जीवो एटा को प्रोविजन अछि किछि जानछथि किछि यू हैव टू एडुकेट मी जदि सेंति प्रोविजन अछि जे जा फाइल करियो आज मोर काम हला नोटिस इशू करिवि सो इट इज एज गुड एज अ पोस्ट ऑफिस
Present petition against the husband.
ऑर्डर 41 देखछथि देखन दियंतु सीपीसी दियंतु
Application.
पहले
41 Rule 3A. Application for condonation of delay.
41 rule 3
Rule 3A, lordship.
कोडा गले
Appeals from original decree order 41.
हां
Rule 3 capital A. Application.
ता पूर्वरो कोन किछि नै
अच्छा,
छोड़ा पड़िबे ना कोन
one form of
1 तापर 3 देखले
lordship, free rejection or amendment.
नहीं नहीं को कोई धरछ 2 रा 2 परे जोटा अछि 3 1 परे ऑर्डर 1 रूल 1 रूल
Order
तापरे 2
41. Order 41.
1 तापरे आपण बेन कथा पृष्ठ उल्टे चलचनी मु पृष्ठ उल्टोनी आपण ऑर्डर 41 रे
Rule 1 Lords.
हां रूल 1 रे
Form
तापरे 3 देखिबे 3 देखंतु where the appeal is against a decree
wait a second.
नेक्स्ट आपण आपण उल्टोचून जानि पारना बडा मते दियो
Rejection or amendment of memorandum.
सेफ्टी किछि लेखा है 1 रो 1 परे जो 1 अछि ब्रैकेट रे तापरे 2 अछि
Lords.
तापरे 3 पढंतु
Where the appeal is against a decree for payment of money,
Hmm.
the appellant shall within such time as the appellate court may allow deposit the amount disputed in the appeal or furnish such security in respect thereof as the court may think fit. Lords.
के अमेंडमेंट केबे आसला तळ कोन फुटनोट रे देखिबे
1999.
1977
The bill has been stated.
कोन बिल कोन अमेंडमेंट बिल नो डेट केबे 1/2/1977 so much before you started practicing also I have started practicing first you have noted आपण कोटा पढिले 3 है तो कंडोनेशन ऑफ डिले
38.
ठीक अछि डेट 10 पढंतु ऑर्डर 41 रूल 10
Appellate court may require appellant to furnish security for cost.
Oh.
The appellate court may, in its discretion, either before the respondent is called upon to appear and answer or afterwards on the application of the respondent, demand from the appellant security for the cost of the appeal or of the original suit or of both.
मतलब 11 टा पढंतु
11.
बड़ पार्ट सेटा टिके आपण
Power to
इंपोर्टेंट
power to dismiss appeal without sending notice to lower court. The appellate court, after fixing a day for hearing the appellant or his pleader and hearing him accordingly, if he appears on that day, may dismiss the appeal. 2. If on the day fixed or any other day,
डज नॉट अपियर सेटा नो तो आपण कोन कहउछन नोटिस इशू करंतु सीपीसी कोन कहला
without sending notice.
आ कोन कहला सिक्योरिटी देबे हैला and please remember nowadays even in my days also 26 years back or 30 years back 30 years back now children used to attend court or not that nowadays the next generation they are coming to court if I get carried away by your submission limitation notice down then what about CPC my senior quoted one of the very senior advocates of this court very famous actually the most famous if you have heard about Mr. Bimal Pal you have heard about his son Vijay Pal so Bimal Pal's junior have become Chief Justice of I mean they have been illustrious chamber he used to say in the veranda his comment
Not make an order for the stay of execution of the decree against which the appeal is proposed to be filed so long as the court does not, after hearing under Rule 11, decide to hear the appeal.
that is again a rider the petitioner before this court is the husband in the marriage by filing the revision application under section 19 into bracket 3 and 4 of the Family Courts Act, 6 revision of the judgment
Let's see, without unavoidable circumstances, the present petition not file the RPFM timely.
unavoidable circumstances को provision है section 5 limitation act को provision है
Financial hardship.
सुना को देखिए ना those are not there
Let's see, pray for short adjournment.
नहीं adjournment नेबे छे but I can't waste my time for adjourning the matters
Let's see.
somehow I have to spend my time in I'm not dismissing your appeal because as you know none of the appeal is yet to be or revision has been yet to be dismissed by me on this ground
Short adjournment.
So you take such adjournment, but not without the order. Then what I'm doing for the last 10 minutes, discussing with you, I have to record that. आइए टा लिखिबे आइए केते हेडा आइए 366 of 2024 along with RPFM. So the judgment I have rendered 2 judgments to 3 ki how when a notice should not be issued in every matter. I would see Ladita got a judgment as a Supreme Court that in every matter the other side should not be entangled in litigation. The court has owes a duty apart from order 41. 1-3 dekile, 3A dekile, 41-10, 11 dekile. Why these provisions are made? Because there has to be, it can't be like more dabar nahi mo High Court case file karchi. That is not a judicious approach. Apana kono karibe, apana so fine, apana secure karibe. Apana je deveni seta, that's a different thing, that's a matter of adjudication. But apana jodi challenge koruchandi kono karibe, the CPC is very clear. You have to secure it. Challenges? Dated 18-3-23. And every time, Madam Patnaik, I cannot be better prepared than the lawyer. It should be always the converse. You have to educate me. It's not it. In CRLMP number 04 of 2021. The said CRLMP was filed by the wife in the marriage and the infant child aged about 1.5 years, represented through her mother guardian, seeking maintenance under section 125 of CRPC. Into brackets, since substituted by perimeter provision contained in 144 of ENSS, bracket closed. The prayer made in the petition was 70,000 per month towards maintenance and 30,000 towards the litigation cost. The petition was favored. However, directing payment of rupees 7,000 to the wife and rupees 3,000 to the child per month, with effect from the date of application, that is 18-3-23. For the further direction was to pay rupees 10,000 towards litigation cost. The revision has been filed after a reported delay of 416 days. But it is submitted by the learned counsel for the petitioner that notice should be issued in the delay application when the learned counsel is apprised, he was requested to address on the merits of the case. But judgment in so-and-so versus so-and-so, it has been held by this court that issuance of notice has to be guided by the principles contained, more so the specific provisions contained in CPC. In that regard, the provisions contained in Order 41 are relevant, which deal with appeals from original decrees and can be applied. And those principles can be applied in case of petition seeking revision. The learned counsel for the petitioner is apprised of Order 41 XLI, Rule 1 into bracket 3. Order XLI rule 3 into bracket 3 dash capital A comma अच्छा order टा होते बारंबार वो repeat कर दूसरा order 41 टा पर सब जगह rule comma दे लिखे थे I hope you understand. Then rule 10 rule 11 in view of the efforts above specific provisions contained in CPC, the petitioner has to secure the amount which he challenges. Secure the amount payable to the opposite parties, wife and child, which he challenges in the revision. The Lord Counsel for the petitioner is also apprised of the judgment rendered by the Honorable Apex Court and the law laid down in Rajneesh versus Neha, petition wherein it has been held that the amount directed to be paid towards maintenance to wife and child under section 125 CRPC is akin to a money decree. केते पैसा देचंती upon on being asked, the Lord Counsel for the petitioner upon instruction submits that the amount towards maintenance directed by the judgment remains unpaid. 30C unpaid stop. The amount due till June 2026. 3 वर्ष होगा 3 वर्ष ପରେ another 140. The amount due comes to intellectual sentence টা amount due comes to 7 into bracket 7 पे जो 7000 जुक्त 3000 bracket closed into 39 जेते ହେଲା. Apparently the matter was kept pending and has never been taken up or has not been taken up. Earlier, the petitioner filed affidavit indicating how he will secure the amount directed. If any amount has already been paid pursuant to the judgment and order, the same shall also be indicated in the affidavit, giving the details such as amount paid, date of payment, mode of payment. The affidavit shall be filed within 3 weeks. The matter shall be listed for orders in the week commencing तेरह सात आज के तारीख होची 24. The week commencing 17/7. Sorry, এটা আমি জুন মাসের আছে না জুন কেতে 24 20/7 shall be listed for orders in the week commencing 20/7. Judgment बहुत छोड़ा का करिए पड़ो regarding issuance of notice what time judgment के मोदी नो है से ओडिया लोक जज को ना कौन के मोदी जस्टिस मनोहर को नो जस्टिस MS साहू ओडिशा हाईकोर्ट था पर देखिए मनोहर को सुप्रीम कोर्ट जजमेंट सी ललिता नोट करते हैं पर देखिए तो Devashish Samal for the petitioner.
My lord, condonation for delay. Today it is for orders. Only 14 days as indicated by the registrar.
So if you want issuance of notice, secure the amount. No further discussion. It is good that similar matters are listed successively. The same discussions are as I was discussing with Madam Patnaik.
My lord.
Devashish Samal for the petitioner. Jit party blank. The petitioner before this court is the husband in the marriage. By filing the revision, he challenges the judgment dated 30/5/2024 passed by the Learned Judge Family Court, Berhampur, in criminal proceeding number 214 of 2021. The said petition was filed by the wife in the marriage.
Wife filed. My daughter and my wife filed.
Of course.
For maintenance 120.
Yes.
Fine.
And the minor daughter born from the wedlock seeking monthly maintenance at the rate of 30,000 for each of them. Stop. The petition was favored, however, directing payment of rupees 15,000 to the wife and rupees 5,000 to the child. तापर रेस्ट जोड़ा सुन नहीं की तो पूरा टा रिप्रोड्यूस करते कितना दे चंती any instruction?
No instruction, my lord. During pendency, already paid. But
During pendency no, pursuant to the decree. Same कर दियो. As per instruction, nothing has been paid. इस तरह यार हिसाब होगा 26/8/21. The amount due from 26/8 from the date of application, that is 26/8/21. Till June कर दियो, till June 2026 is 58 months into 20,000. कितने डेट को चुन 13/7 ना
20
रजिस्टर 20/7 एफिडेविट पे
13
चेक करो डेट है 13/7 नहीं दे दो मैं तो हो तो इस पे डेट even if it is more than 3 weeks, they do. हाँ 15/7 वाले पढ़ो 15/7. Yes.
Affidavit within 3 weeks, my lord.
15/7. Every time नहीं होता. This is not the place to bargain the decree, sir. आपका जो ulterior ego, I will not pay, is not to be tested with.
But factually, that issue is not being determined my viability of income. I am a daily laborer.
Pleading देखा तो मुझे बर्तन dispose of कर देगी.
Already.
You must understand. I am encouraging all of you to argue that. देखा तो pleadings. देखी चंदी अपन आगे written statement देख चंदी.
Already in the judgment, my lord.
Judgment पर written statement जान दो चंदी.
No, my lord. My stand already. I have taken.
सामल अपन पिकाल दर्शी वाले पूछंदी. अपन pleadings देख चंदी written statement से stand अच्छी.
That.
But written statement you stand ever कहले by liability to pay has not been determined.
Mine.
So stand नहीं चंदी.
That stand I have not taken.
125 से 125 125 CRP से कौन कोर्ट रेट पावर अच्छी थी मजिस्ट्रेट कौन देखियो
Only the income and also dependence, that also income.
Who section red अच्छी income dependence कोठी अच्छी Of course, income is a factor. Seটা
Income is a
definitely.
factor.
Seটা কিন্তু ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଯେ ଆପଣ liability determine ହେଇନି ସେଟା
সেটা জিনিস বাসন নেয়ার affidavit also viability both wife and husband.
ଆପଣ ସେ stand ନ ନେଲେ ବି 25% ନେହା କୋଉ paragraph ରେ ମୁଁ ତ ବହୁତ ପଢିଲିଣି କୋଉ paragraph ରେ ଅଛି ଯେ କିଛି
I have taken in my appeal ground my.
କାହିଁ ସେଟା କରୁଥିଲେ? Why you are weakening your case? When you take a plea not taken before the revision, revision में कोई judgment. What are the principles of revision?
Revision that factually and that the issue already not been framed about my viability of income.
ଏଟା କୋଉଠୁ ଏଟା ମାନେ ଆପଣ ଗୋଟେ ସ୍ପିଚ୍ ଦଉଛନ୍ତି ନା କୋଉ ଜଜମେଣ୍ଟ କଥା କହୁଛନ୍ତି?
No, that
କୋଉ ଜଜମେଣ୍ଟ ରେ ଆପଣ ରିଭିଜନ ଫାଇଲ କଲା ବେଳେ କୋଉ ଜଜମେଣ୍ଟ ଦେଖିବେ? ପ୍ରିନ୍ସିପଲ୍ସ ଅଫ ରିଭିଜନ କିଛି ପଢିଛନ୍ତି?
that is
Sir, we are not playing here to gallery playing to the gallery.
no man.
You require solid performance.
Man.
Your speech can be matched by my speech, but why I'm not speaking? We are not in a debate competition. Apart from whenever you file a revision, just check where the principles have been laid. The learned counsel for the petitioner is also apprised of the judgment rendered by the Hon'Ble Apex Court. In ଆପଣ ମାନଙ୍କ ସାଙ୍ଗେ deal କରିକି ମୁଁ ବି ଭୁଲି ଯାଉଛି. Because I have also developed a habit of not keeping. Tamima Faruqi versus Sahid Khan, paragraph 20 and 21, where the Hon'Ble Apex Court has dealt with the scope of revision by this court of judgment passed by the family court in exercise of revisional jurisdiction. Samima Supra citation dele was a application arising out of SLP was arising out of a petition under section 125 CRPC. Paragraph 20 and 21 of the said judgment are reproduced here. And that is the reason, Mr. Patnaik, I have to do this. Because ଆପଣ ଯୋଉଟା argue କରୁଛନ୍ତି, that is just opposite to what Supreme Court has laid down. Those principles are old. It's not divisional jurisdiction, it's old principle. Honorable Justice Deepak Misra has, in his beautiful language as he does, he has done this. And Samima has been cited in Rajnish. Rajnish's judgment date kete?
631.
এটা তারপরে apparently it is after that, but anyway সেটা আপন যেটা কোচন যে yes, next
item 20.
May it please your lordship, I am appearing on behalf of Mr. M.K. Mahapatra.
Your name, sir?
My name is Gopal Chandra Das.
So Gopal Chandra Das on behalf of M.K. Mahapatra. TRO selected M.K. Mahapatra for the appellate. ଆପଣ ଏଟା ଅଫିସ ନୋଟଟା ଦେଖିଛନ୍ତି sir?
Yes, your lordship.
ପଢନ୍ତୁ.
As per report of SR, court fee of rupees 7,034 exempted as the appellant are under ST community. Last certificate of appellant number 1 is filed, but counsel for the appellant filed an IA number 343 of 2024 is at flag A for exemption from payment of court fee.
So that ST community, how the staff reporter could know? You have filed the caste certificate?
We filed it in IA, your lordship.
Caste certificate?
Yes, your lordship.
You obtained instruction? Not. Nature. Annexure 8, page 5 in the IA. Copy, sir, Mr. Chetty?
Yes, sir.
LAA 36 of এটা ଆପଣ IA টা লিখিবে IA টা হচ্ছে 343 of 2024 and comma देके तब लिखा LAA 36 of 2024 appearance लिखिए project proponent को पार्टी करचंदी
Land acquisition officer.
see project proponent no what is the difference between project proponent and land acquisition officer
Land acquisition officer acquire land on behalf of the project provider.
under which act
Land Acquisition Act.
so then what is the difference between the officer and the proponent Suppose let us take the example of the Mr. Patnaik was arguing. What Mr. Patnaik was doing, he was appearing in a matter. Then what is the role of a judge? He is the administrative authority. He is not the project proponent.
But the notification it was issued by the state government.
It has to be. Who else will issue, according to you? We are being watched, Mr.
I seek an adjournment, Your Lordship.
No, don't seek adjournment because whatever injuries you have done to your case, I have to repair them because I don't have a choice. You have to waste your wastage of time. Always, you have started recently. What about they find that the lawyer is not carrying any book. The notification declaration that land is required for public purpose is section 6. That authority is state government, which you are saying that state government notified. For a land acquisition collector has been defined. The requisitioning authority has been defined. Everything is there. The IA has been filed for exemption of court fee, applicable court fee. The staff report says that court fee of rupees 7034.25 is exempted as the appellants belong to the scheduled tribe community. Staff copy of the IA has been served on the learned architect and the learned counsel for the state, who shall obtain instruction. Mention of the cost title of the appeal indicates that the co-project by sir petition they may put on
Yes, Your Lordship. Autornal minor irrigation project.
the land was acquired for Bodana.
Autornal.
Which I like explain.
So in synopsis part.
No say chada.
Point number 2, paragraph 2 of petition.
Petition synopsis chadam too. So go to the original document. Not go to file the who case take 36 of 2024.
Yes, sir.
Go to page 47. Construction of Dhamandhar minor irrigation project. With a declaration number 17497 dated Surface January 2005. In the LAR case before the Lord Civil Judge Senior, the Lord Senior Civil Judge Dharmagada, in LAR number 75 of 2019 under section 18 of the Land LA Act 1984. The 1894 was in 1984. Like, the LA Act 1894. as well as in LR number 58 of 2000, upon challenge quota groups. LR 49.
49 of 2022.
49 of 2022. The project proponent, that is Irrigation Department, Government of Orissa, Public Concern Department has not been made a party. In view of the judgment rendered by the Constitution Bench of the Hon'Ble Apex Court in State of Punjab, sorry, UP Awas Vikas Nigam versus Devi. Gyan Devi is the Gyan, sir. You should have Gyan of Gyan Devi. And that's the Constitution Bench decision, 1993. The project proponent has to be heard in cases where enhancement is sought for. Enhancement of land acquisition compensation is sought for. The petitioners shall obtain instruction and take steps for including the project proponent. As respondent in the present application. The learned access standing counsel shall obtain instruction. Lower court re stand court fee exemption in the lower court also you are exempted because you are belong to the particular community who are exempted. Let us the matter shall be listed for orders in the week commencing.
Your Lordship,
Decision gone.
Gyandev.
UP Awas Vikas Nigam. You have to develop the habit of remembering case, at least party names. Gyandev you will find him, of course, if you search in Google or do something, then you will find it. Otherwise, it will be real struggle, sir. You have to develop that habit of remembering because you will be appearing in those matters. Now you have found out that your proposition that Supreme Court did not realize. LAR is a party, land official is a party.
Your Lordship, the imping order that I have challenged, that LAR number 49 of 2022, the project is actually Atharnala minor irrigation project at page number 11.
LA 36, right?
That is the, we have taken the relevance of other cases. 18 is, Your Lordship. In trial court, before the because
land acquired, suppose a land is acquired for one project, it has to be the same project and same land.
The value of the land.
One mistake is that the project proponent has not been heard. That is fatal. Because it's a judgment laid down that article. Which article makes it mandate the law of the land?
300A.
Which article of Constitution makes the judgments pronounced by the apex court as law of the land? Which articles? Plural against Article 140 and 142. So that makes your application, the determination by the learned trial court is gone. Then in your petition, how do you cite Atharnala re say kon bandha ki bandha seta kon tar related? How it is related? Wherever the road is constructed, suppose a road is constructed here, and another road is constructed in Chaudhar. Can you cite Chaudhar because Chaudhar the rate is this? So for this the rate is different. For enhancement, it is usually at the same place.
Lordship may adjourn this matter. My senior will
It
appear.
has to be. I have already adjourned. What is the date of adjournment?
Lordship.
What is the date I have adjourned the matter?
I know.
You know,
I was worrying about,
you did not worry because I have to repair it. But just since you have raised this, at least you have started thinking. Did para 5. Para 5 at phase 12.
In order to prove their case, the petitioners have examined petitioner number 3 as PW1. He has filed the certified copy of judgment in LAR number 58 by 2019, LAR number 75 by 2019, and 87 of 2018.
Which project? The project is conspicuously silent. Of course, it will be easy to blame the judge or the court. But did the lawyer did the right thing? Suppose, let us assume that you can cite it, but at least you bring to the notice of the court. Is it every time that the way, it is not that I'm much more prepared than it's a habit of reading. And suddenly you find that it is author Nola and the citation is of some other case, LAR 75, 87, they are of some other project. Only. There is a paragraph 5 of the judgment of rendered by the so and so court, senior civil judge, indicates thus. The paragraph 5 of the judgment rendered by the so and so in LAR 49 of 2022 indicates thus. Para 5 ta quote kar de. The 875 is 7. Copy of the judgment rendered in LAR 58 of 2019. Judgment dated 24/9/2021 indicates that the acquisition was for Hon'Ble minor irrigation project. Page 37 पे पाएंगे ना, देखिए बोल दो project with a notification letter and declaration para 2 रे देखिए 75 रे लिखो तो para 2 से श्री Hon'Ble It's space corridor. It's corridor. 75 ର पेज केते पड़े पेज कहली ना ये समस्त मिसी कंफ्यूज होगा केमती हो पेज 37 ने पैराग्राफ 2 लिखी LAR 50 LAR 75 रे page 47 page 47 and 40 is the paragraph 2 or LAR 87 LAR 87 of 2018 page 54 paragraph 3. Same another counsel for the appellate as adjournment to appraise how the acquisition for the Hon'Ble irrigation minor irrigation project is relevant in acquisition for Hon'Ble minor irrigation project. the least you should do, I'm sorry, I forgot your name again, sir.
Gopal.
Mr. Gopal, that you should be encouraged, because that is how you start doing cases, get involved. Not that simply, at least you have spent time, you have thought about something. So check କରନ୍ତୁ ସେଇଟା.
One more thing, there is in
The learned ACR shall also obtain instruction. Dhamandhar ଅଠରନଳା କଣ ମାନେ cousin brother ନା କଣ? Cousin brother concept LA ରେ ଅଛି କି ନାହିଁ? ଯୋଉଠି ଯାହା project ହବ ଧମନ୍ଦର ଅଠରନଳା site ରେ ଧମନ୍ଦର site ହବ. And this is a real problem, Mr. Gopal. Suppose in Puri, Supreme Court directed that you pay the amount by negotiation for Sri Mandira Parikrama project. Then wherever the land was acquired for road construction or expansion of certain projects, those amounts were not paid. And that is a genuine grievance. I mean, that's a genuine, what you call, grievance or whatever. It's a grievance raised by all the land trustees that they got more, we got less. And same for Puri. That happens. But that cannot be paid to everyone.
Your Lordship, the rate that was fixed by the government trial court in the subsequent project that has been mentioned in the witness.
Subsequent court, give
Yes,
the
sir.
name.
In the prior, the acquisition of Dhamandhar minor irrigation project, and the project in this that is challenged is of same village, one village.
Sir,
but different project, Your Lordship. So value of the land.
You must understand the complete incongruity in your argument. When CDA was constructed, looking at this, land was acquired, the rate was something different. Now, what would be the land if acquired for road? Yes,
It will be more.
much more.
Much more. On that ground, Your Lordship, we are challenging that during that.
Basis is not there, sir. You have no basis to challenge. The court, because you did not apprise the court, when the court has quoted that, it has not referred to the which project. It cannot be. And you must take a hint when I was dictating, I was giving the details. The notification number, so and so. So even the time, there is a timeline. What is the cost of Bhubaneswar, land in Bhubaneswar offered by government for 2.5 goods, 45,000 square feet? Can you guess? He stays in Bhubaneswar. He may guess. What was the cost of land? Government was offering the rate of land.
50,000 back in 1990.
50,000 is too high, Mr.
1990. Like
I'm
Sailesh,
I'm talking about when the Bhubaneswar was started
that is way back.
in early 60s.
That is 5,000.
Still too high. It was in hundreds. Unta 200 टका, 300 टका, 300 300 नहीं, 300 टका ठीक है कम. बर्तन acquisition है आपन 300 टका पकेबे. Benchmark valuation अच्छी. There are so many things. आपन कौन से basis रे apply करछन्ती आपन निजे जानि ना. अब पैसा enhancement हे गला without hearing the project proponent. Because the project proponent pays the money, not the land acquisition officer. He receives the money is deposited, he distributes it. आपन जो objection अछि section 18 रे गले civil court. जे हम enhancement चाहूछु, that's a different thing. But he is not the person who is giving the money. Nowhere government pays for money unless even revenue by revenue department, irrigation by irrigation department, R&B by works department. Not the building ta theory hobo, hospital building theory hobo. Se one acquire kale, apanakara ye department, kon seta health and family welfare department. It depends kiye paisa dauchi, taku apan shunibe. Apan mane court, yes. Instruction the order is detailed, so can follow that.
Yes, sir.
Yes, next.
Item 21.
Obliged, Your Lordship.
Kindly see flag A. There is an application for change of nomenclature from RPFM to WPC.
Mr. Vishwanath Patnaik for the petitioner. IA 429 of 2025. My lord. The application has been filed for change of nomenclature from RPFM to WPC. The staff report dated 15/9/2025 at entry 9 indicates nomenclature not court re likhibe nomenclature not correct, comma, it may be registered as WPC. Stop. Accordingly, the prayer made in the IA is allowed, the IA is favored and disposed of. The petitioner shall take steps for correction of the nomenclature, the registry shall do the next. The petitioner shall have liberty to move the assigned bench for listing of the matter. Yes, next.
Item 22. Kindly take up next week.
Today is the best day, sir. We have already discussed 2-3 matters, so it will be discussed on
was missing anyways.
So that you will not be confused and you will not confuse me also. Like the other matter. We are stuck which project is it a line duration hela. The petitioner, Mr. Jayanta Kumar Maji, for the petitioner, paperless so that is meant for you only. Jayanta Kumar Maji for the petitioner. The petitioner in the application is the husband in the marriage. He seeks revision of the judgment dated 6/2/20, judgment and order dated 6/2/2025, passed by the Lord Judge, Family Court, Baripada, in CRP number 211 of 2024. The said CRP was filed by the wife in the marriage, seeking wife in the marriage under section 144 of DNSS, 2023, seeking monthly maintenance from the opposite party husband. केते टका मागिथिले? Monthly maintenance at rupees 10,000 for the wife and rupees 6,000 for the minor's child, one from the wedlock, and 10,000 towards litigation expenses. The petition was favored, however, directing payment of rupees 4,000 to the wife with effect from the date of application 3/10/2024. कितना देचुन की जे जानना है. The learned counsel for the petitioner upon instruction submits that the petitioner has not paid any amount as directed by the learned judgment, as directed by the learned family court. The total amount, the learned counsel is apprised of the item 18-19 जोटा जोस्ना मैडम नहीं नांती की तब डिटेल अच्छी तब छोड़ा रिपीट है जो एफिडेविट देवे
Yes, sir.
यो तो सर कितने तारीख का डेट है तो मिस्टर बारी
Odisha.
एफिडेविट बाय 13/7
13.
सेम करो 13/7 एफिडेविट दियो तो कोड़े पैसा जदी दवार नहीं एठी आसंतु नहीं. Don't show your ulterior ego to a court, because court has empowered with lot of power and all that. So there's no point in court re kave mu kichi debar nahi. It is better to bang your head on the wall.
Yes.
The due to amount नहीं उनको डाकी लिखना डाकी डेट कितने को है? 10 नहीं टोटल ड्यूज 3/10/24 4,000 टका खर्च नहीं कि 4,000 हम 4,000 मंथली मेंटेनेंस 5,000 टका चाइल्ड को कौन छाड़ देले कोर्ट 5,000 टका litigation expenses. The amount of due up to June 2026 comes to 4,000 into 20. 80,000 टका सेटा मेंशन होला. Yes, next.
23. File na आए for converse.
Item 21 टा अपन नहीं चेक से same order. 23 रे Mr. Pradeep Kumar Das for the petition, opposite party blank. এটা লা হয়ে গেল কোন এটা?
এটা WPC
ল্যান্ড ডিভিশন আপিল লিখেছি ভুল রে।
interim order টা
WPC সেম অর্ডার হবো। IA 458 of 2024 বাকি দেবে না সেটা এই করি পারি কনভার্সনটা সেম অ্যাপ্লিকেশন ঠিক আছে। Yes, next.
24.
Petitioner none. आइए लिखिए मेरा पिटिशन appellant LAA 24 and LAA. Mr. Ansuman City.
Yes, sir.
Ansuman City for Mr. Ansuman City AC for the opposite party. None appears for the petitioner when the matter is called. None appears for the appellant petitioner, appellant dash petitioner. The IA has been filed. IA 55 of 2025. वो नोटा के लिए अपन लिखी हुई देखिए ना. The IA has been filed for exemption of paying a deficit court fee of rupees 6572.25. 6553.25 para. To grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing 27/7/2026. Upper लिखो तो perusal of the clause title in the appeal memo indicates that the project proponent of the rate irrigation project RET rate সেটা তো ইংলিশে রেট হয়ে যাচ্ছে RET rate irrigation project at post PS Bhawanipatna district Kalahandi has not been made a party. The land acquisition and rehabilitation officer under the Land Acquisition Act has been made a party who is not the project proponent. Stop. In view of the judgment rendered by the Hon'Ble Apex Court, the judgment rendered and law laid down. In view of the law laid down by the Hon'Ble Apex Court in UP Awas এবং Vikas Nigam versus Gyan Devi petitionটা দেবে for seeking enhancement of land acquisition compensation, the project proponent has to be made a party. The petitioners, the appellant shall have the liberty to take steps for impeding the project proponent as a party. Next.
26.
6 lords. The petitioner is the husband.
Your name, sir?
Brahmajyoti Tripathi.
You Mr. Raman Jyoti.
Brahmajyoti.
You have power here B. Mr. Brahmajyoti Tripathi. You should have brought MS Sahoo. MS Sahoo is your associate. So Brahmajyoti Tripathi for the petitioner, opposite party blank. Yes.
Here the petitioner is the husband and has preferred the aforesaid revision, challenging the judgment dated 25/8/2025, passed in CRP number 34 of 2022, passed by the Learned Judge, Family Court, Kendrapada, praying therein to set aside the same, and in filing the revision, my lords, a delay of 83 days has been.
So have you paid anything?
No.
The same order as in eta kitte item eta?
26.
26. Same order as in item 18. 18 टा किए नीचे बुझी रहे ताको आनी की गोटे प्रिंट करी की 18 टा हेगला पारे ताको रिप्रोड्यूस कर देता एफिडेविट दियो तो केबे पैसा देबे 13 7 रहउची up to 13 7 listed on 20 7 be clear on this point that here this kind of bargaining or showing your ulterior ego will not help this court of law that yes ସେମାନେ ବି execution file କରୁନାହାନ୍ତି because they are frustrated. They went to the court, got some maintenance, you are not paid. They may, I mean, they resile to fate and they don't claim any, execution. So they don't lose execution. But that doesn't mean that the court will also aid you. Yes, next.
27.
The Bhukta. Notice petitioner none, the matter shall be listed. To grant further opportunity, the matter shall be listed for orders in the week commencing. 27. Call करो तो quick
29.
28 order डका हवा अपन तो 29 28 देखो
28.
अपन खाइ जो लॉन्च आवर पर टिके जो होचंती बैटरी डाउन होचे अपन तो सेटा जगंतु Mr. R.R. Naik for the petitioner. Opposite party blank. Office note put up by the registry indicates that notice on sole opposite party by a speed post with AD has been returned undelivered with postal endorsement within quote insufficient address. Hence returned to sender. Quote ends. Para, it is submitted by the learned counsel for the petitioner that the petitioner shall find out the present correct address and take steps afresh for issuance of notice. Stop. Prayer is allowed. The petitioner has time. Petitioner is granted for the time till 10/8/2026 to discover the present correct address and take steps. Upon requisites filed for issuance of notice, notice shall be issued to the opposite party, fixing returnable date. Or 10/8. Fixing returnable date 10/8/2026. The matter shall be listed for orders on 17/8 in the week commencing 17/8/2026. Yes, next.
29.
Mr. P.C. Das for the petitioner. Ashwini Patnaik. So Ashwini Patnaik for the opposite parties. Memo of date is filed by the learned counsel for the petitioner, which states thus. Into bracket C. The memo shall be taken on record, scanned copy be updated. The petition stands disposed of.
30,
Mr. Rajkumar Sutar on behalf of Hara Prasad Ratha for the petitioner. Mr. Nayak for the additional standing counsel for the opposite party. The learned counsel for the petitioner seeks further time to file rejoinder in response to the counter by OP number 2. Stop. Accordingly, the petitioner shall have the liberty to file rejoinder upon serving copy thereof on the learned counsel for the state. The matter shall be listed for admission. Commencing 3/8/2024. Yes, next. Again, sir, typographical error. The Puburu typographical error ta correct karo. The office note put up by the registry indicates that inadvertent typographical error has crept into the order dated 9/5/2026. The order number having been incorrectly typed as 1 instead of 3. Stop. The necessary correction be carried out in the order as per rules. Stop. Correct लिख देना. तो भुगता आपन का मैटर कौन है ना
27
आपन करिबे ना खाली adjournment हेले चलिबो ठीक अछि
नोटिस ता जीवो
डिले नोटिस जाय करनी अछि आज डिले रे जो ऑर्डर हिची आपन एफिडेविट जे देबे पैसा देबा पई ताले सेटा हबो
ना आई एम पेइंग रेगुलर
ठीक है होटल टिके रूम तो हियरिंग करे ठीक जस्ट पास हो केलो तापर आउ कोडा पर जिबे ना हां ठीक है call
31.
Your Lordship, on behalf of Mr. SP Mohanty, I pray for an short adjournment, Your Lordship.
Yeah, after notice matter, I will not start hearing.
Noting is there, my lord. Contesting OP number 5 and 4 and 5. He did not appear.
Oh, अच्छा. Oh. That has to be sufficient.
Not.
It a high period. जब लैंड एक्विजिशन ना कौन
No, the selection of TGT scale में जो ट्रेंड
अच्छा ताले तो ये तो दरकार योर नेम सर आपन का नाटा
Udipta Kumar Panda, Your Lordship.
सुदीप्त कुमार
Udipta, Your Lordship.
महांती for the petitioner
Talani Prasad vetted for officer on behalf of SK.
again
On behalf of SK Mehta, opposite 7 Talani
अच्छा ठीक है just give me a second So Nayak additional standing counsel for one to parties 1 2 3 1 2 and 3 English 2 है ना So Tarini Prasad Tripathi for OP7 the matter is listed for hearing under the heading after notice है ना तो notice the court order ଆପଣ additional affidavit serve କରିଛନ୍ତି copy ये जानना है Mr. Nayak additional affidavit कौन है
additional affidavit in DC counter में additional दे ना थे they have petitioner filed to additional affidavit
ଆପଣ counter ତା ଦେହରେ file କରି ଦେଇଛନ୍ତି
ଆମେ counter file କରି ଦେଇଛୁ
अच्छा the learned counsel for the petitioner seeks for the time to in absence of the learned arguing counsel नहीं change कर लिखो बेटे adjournment is sought for on behalf of the petitioner in absence of the learned arguing counsel. Stop. Office note put up by the registry indicates that AD not received from OP number 4 and 5. कौन steps नहीं होता क्या? इतना simply पके रखले कौन होगा 19 मसीहा केस. Next steps. बाजी कोमनी अपन जाड़ी ना थी तो but talk to the senior.
Your Lordship.
In the view of in these matters, non-appearance of the parties, the matter cannot be heard. Please appreciate that.
Your Lordship.
The matter shall be listed for admission in the week commencing. If you are taking steps, you can mention so that I will pass orders.
Counter copy file by the state not sought to.
Fine, no. Additional affidavit?
No.
पण किछि काई आपण किछि दउनांती
9/4/2026 रे ऑर्डर हेतिला देखंतु
the learned counsel for the OP number 7 submits that he has not been served with a copy of the counter filed by the state, counter filed by state OP number 2 and 3, as well as the additional affidavit filed by the petitioner. Learned counsel, the learned additional standing counsel shall serve copy of the counter on the learned counsel for the OP 7. Copy of the additional affidavit filed by the petitioner shall also be served within
Within 2 weeks, Your Lordship.
2 weeks nebe, within 7 working days. Our steps niyantu par author press notice niyantu 4 and 5
This is the second time we have taken the notice, Your Lordship.
second time neleni
Yes, Your Lordship.
neitile
Yes, Your Lordship.
se appeal karibeni. But why it is not sufficient? Sufficient hele sina court proceed kari paribo.
Your Lordship.
Yes, next
32.
प्रथम 32 रे 18244 of 2022 अलगा अलगा लिखियो पड़ो काहे कि एटा अपीरेंस अलगा अछि. Miss Babita Kumari Patnaik for the petitioner. तेरे टाइम किए मागिले मिस पटनायक मागिले Mr. Naik, additional standing counsel for opposite parties 1 TO2 4. OP5 Mr. Prasanta Kumar Satpathy. The learned counsel for the is listed for hearing under the heading admission or admission. Learned counsel for the petitioner 6 accommodation to advance appellants. The learned counsel for the OP number 5 submits that the matter is object as OP number 5 is not receiving any salary and is facing immense difficulty. Stop. The matter shall be listed along with the connected to WPC 1848 of 2020 in the week commencing 27/2026. Interim order dated खोजी बाहर कर दो ना, shall continue till the next date of hearing. Next लिखो to WPC 1848 of 2020. इसीटा बंद कर दो. I hope माने गरम लाଗୁଛି बंद कले चलिबो त. हां सर बंद के कौन लिखले 1848 of 2020 Mr. Prasanta Kumar Satpathy for the petitioner. Mr. Naik additional standing counsel for the P 1 TO2 4. Naik इतने क्या appeal कुछ other OP पे क्या कर नथले. Anyone present for the other OPs?
Not present.
Okay. It is submitted by Mr. Satpathy that he appears for the petitioner as the petitioner has obtained change. Stop. Name of Mr. Akshay Kumar Pandey shall be deleted. Appearing for the petitioner shall be deleted from the cause list as well as the case brief from the next list. The matter shall be listed along with the WPC 18244 of 2022 in the week commencing 27/2026. Interim order thick check karibe. Check. Yes.
33.
Is Manchik.
I'm appearing for petitioner wife minutes. There
Yes.
is a transfer petition minutes
Yes.
for transfer of the CP
You
proceeding.
are Mr. Hussain.
Yes, minutes.
Mr. Sheikh Zakir Hussain for the petitioner. Mr. Prabhat Kumar Mahanti for the opposite party. Mediation re kon hela? Agree kale?
Mediation sir fail he gala.
Successfully.
खाली ट्रांसफर पाई आपण भी राजी होनांती गोटे जागा बोथ ऑफ यू डिसाइड ए प्लेस
नहीं ट्रांसफर
what you can do, you can suggest. I will not record any kind of concession because if the parties are fighting it out.
Let's.
Sir, both parties are staying at Hyderabad, working at Hyderabad. So,
कटक भुवनेश्वर हेला आपण माने करि परिबे
आज्ञा
आपण से इंस्ट्रक्शन नियंतु
my lord,
चाहूछथि सर
my lord, already the in family court Cuttack, the evidence is already started. Cross examination is started and deferred.
stay
ହେଇଛି ବର୍ତ୍ତମାନ
stay ନା status माने defer
stay ହେଇଛି start ଯେତେବେଳେ defer ହେଲା ତାପରେ my lord stay ହେଲା defer ପରେ stay ହେଲା.
I hope Mr. Hussain what your learned senior is saying you will understand.
No, I understand, but
What he said?
I said that the matter be posted at Cuttack.
First part was important.
Okay.
Always be attentive. He did not say many things, but he said very significant things. Suppose this court will consider the part where the parties are staying. Both the parties are staying at Hyderabad.
Yes.
So this court lacks complete jurisdiction. That is one way of looking at it. Where do you want?
Look, we want in Cuttack because my parental home is in Puri, sorry.
Puri, how is it relevant for you? By staying at parent mane the party hi chanti ki?
The parent but
suppose let us I am impressed with your argument. I will pass a order. The petitioner stays in Hyderabad, works in Hyderabad, and since her parents are staying at Puri, the matter should be transferred to Puri.
There's already one matter is already continuing in my lord. A DV case is there.
Are apanakara don't just reproduce what your client is saying. You must think about the legal aspect. I think the best place would be Cuttack. Because if you are arguing here, you can take care of the matter here.
It's not, from my perspective, Cuttack is fine.
Your perspective, which provision is there that where the parents are staying?
There's no provision, my lord. Just for the sake of convenience, my lord.
So which provision sake of convenience?
I'm citing as some judgments, my lord.
Which judgment?
It says wife's convenience has to be seen, my lord.
Which judgment?
I have cited one. I have copied of it.
No. Instead of handing it over, you read it.
Yes, my lord. It says.
What is the first session?
It is, my lord, Sumita Singh versus Kumar Sanjay.
Yes.
Just one observation.
So in both the cases, Sumita Singh, where Sumita and Sanjay were working in Hyderabad.
No, I'm not aware of that.
That's the problem.
A short judgment.
Because there are more elaborate judgments on this, but
I understand.
But you never find this convenience.
Lord.
And this is a High Court or a Supreme Court judgment?
It's a Supreme Court judgment.
That's still more difficult. 141 power I don't have. Because Supreme Court can observe that for convenience, because it has 141 power. 141 power takes up the statutory limitations also.
And the problem is her father is.
Because section 24 of CPC nowhere speaks about convenience. And it says it can be transferred after hearing both the sides. If suppose you are arguing your convenience, then why the provision is for hearing other side?
Understand.
So there is no such order. There is no such provision that only because then that distorts the entire thing. Section 24, Section 9, that Hindu Marriage Act, everywhere there is no such convenience because rather it is specific.
Well, had there been an infrastructure in the family courts for video conferencing, they would have opted for it, Malak. But there is sadly no such.
It is there. That argument to make in Andhra Pradesh or Telangana. In Odisha, it is there.
It is not non-functioning.
No. Don't second guess things.
No, but I have experience and I have appeared.
Which place you have experience of the video conferencing non-functional?
Puri, Malak, I'm saying about Puri.
Puri?
Yes.
When you had this experience?
So there,
Puri, Hyderabad you should have. Puri re kon karibe you are confused or I am confused? You are saying Puri the parents are staying.
Malak.
So they have nothing to do by being present in video conferencing.
How will she take care of everything at Hyderabad, Malak? She's the only girl. She's not getting leaves also, Malak. She's not getting leaves also. She's working at a bank.
Mr. In Cuttack, in Puri, she'll be granted leave.
But Puri, at least she has her home, she could come there.
So what is the difficulty in coming to Cuttack?
Again, she has
So
to come
for
alone
Puri,
because
you see, your argument is that she's not getting leave.
Malad.
So for Puri, she'll be getting leave.
The problem is her
No,
father
please
is.
answer. It is not a debate competition.
I'll just clarify.
No. Clarify, but don't. It is not a speech. You have to be relevant.
I'll
That is how I have to interject you.
I'll explain.
You are saying that Puri, the video conferencing is not available, which is factually wrong. So the second perspective is that you are staying in Hyderabad. So let us assume that Puri it is available. How it will help you?
For Cuttack, she has to come alone and go because there is no one to.
She can stay alone in Hyderabad. Cuttack is a scary place.
No, not a scary.
You must understand. If I write these things in my judgment, it is laughable. It is laughable. It becomes a joke. She stays in Hyderabad. She cannot come alone to Cuttack. She can travel alone to Puri. Puri, the interesting part is Puri, the video conferencing is not available. She will from Hyderabad. Which place is direct shorter as far as Odisha is concerned, Cuttack or Puri?
Cuttack.
So that goes. So the first line logic is contradicted. Today this is happening. Second line is contradicting first. Third is absurd. How it is absurd? That non-ability of VC in Puri. No, maybe factually correct or incorrect. Actually, it is incorrect. कौन आपको बुझेइबे आपको
I leave it
irresponsible बेले बेले आपण माने जाती. Do you know who the Puri, the portfolio judge, is chairman of the committee? People will be mortally scared that gote ghanta band ho gale, and Puri you will find every day somebody was appearing. In fact, unfortunately, he has Mr. I think Sodangi, who passed away recently, heart attack ho gala. Panigre. Tilochan Panigre. Thank you. Every day he will appear. I will have a joke with him that apna Puri padele tapare se koibe. And Mr. Das at Ashwini Das at Sambalpur. Se aji eti thibe kali se Mr. Kumar Sambalpur aschi. Pordino fer ase Cuttack re asibe. The portfolio judge of Puri is a tough judge. He will never. It will not happen. Upon Supreme Court, the Honorable CJ has cited Odisha for this. That happens everywhere. That is a possibility. Another problem is that in one matter, Mr. Depta was appearing in Sambalpur. First half, second half, it was non-appearance. When he appeared, he said that because in the first half, the entire slots are booked by the other council. Rather, you can say that there is facility is overcrowded now. I cannot justify my judgment by passing, even if I accept your judgment that Puri is better. Puri, because Puri re apankar father parents rochanti, you work at Hyderabad. Completely, in contrast. And Puri re apankar VC facility achi ki nahi is immaterial. And but now I am thinking that that which you did not argue, that suppose one person who has a case at Cuttack, can he appear in Hyderabad? As far as interstate is concerned, court is not having any facility. But how can your appearance be exempted? And Cuttack is nearer to Hyderabad as far as connectivity is concerned. Upon wait karantu international airport hele argue karibe. Aji withdraw kar diyo. Upon instruction niyontu. I think it is better. You at least you can guide her here in Cuttack.
I have.
Yes. Seta karon. A case, the other aspect that this case has been precisely filed to stall the proceeding. Actually, this transfer jurisdiction is completely meant for now. It has been a classic case. When Hyderabad achandi se Cuttack Bhubaneswar prefer kariyo. Se Puri re kohibe Puri re parents thai paranti okilo sina dekha karibe. Other than that konta hai pariyo. Kichi adhika hai pariyo. And number of litigations is so high in Bhubaneswar that data court khala helani. You even Puri lawyers they consult Cuttack lawyers. आपको amendment ये देखिए. I know some, I mean, one of the oldest chambers in Puri. P.K. Das going to even Dwarikanath Mishra, I had the good fortune of knowing them. And otherwise, not as a lawyer, otherwise janichi because of my but instruction new. That question number item.
33.
The learned counsel for the petitioner was heard at length. It is submitted that the petitioner works at Hyderabad, stays at Puri. Her parents, I'm sorry.
Sakhi upar, my lord.
More bhulbal hai lage apan kotha.
Puri question.
Petitioner works at Hyderabad, stays at Hyderabad. However, her parents stay at Sakhi Gopal. Sakhi Gopal, very near to Puri. For which C6 transfer of the pending CP at present pending before the Learned Judge Family Court, CP number ta pakliye. सेमती किछि नाही जे आपनकर मे बी लैक ऑफ कॉन्फिडेंस बेले बेले के जण कहउछन जे हमको वकील हैरान करछन जणे कहले सुनु नांती सेमती दैट कैन नॉट बी इशू आपण जदी वकील को देखा करिवे you pay their fees, they will respond. They are meant for that only. CP number 615 of 2023 pending before Learned Judge Family Court to the Learned Judge Family Court at Puri. It is submitted by the Learned Counsel that the virtual court facility is not working at Puri. The said statement has to be taken with a sack of salt, not a pinch of salt, actually. Assuming, there can't be any reason why the virtual court facilities are not be functional at Puri. It is common knowledge that in Odisha, every district headquarter, every headquarter station is having a VC facility. Stop. Assuming that the VC facility is not available at Puri for the sake of argument, petitioner staying at Hyderabad cannot avail the benefit of the VC facility if at all she requires the same. It is further submitted by the Learned Counsel for the petitioner that the petitioner has to travel alone to Cuttack. The said aspect has to also to be considered in the context that the petitioner stays at Hyderabad and anyhow she has to travel to appear before the court in Odisha. Stop. Mr. Mahanti, Learned Counsel, appearing for the opposite party, opposite party husband submits that the CP pending before in the CP pending before the Learned Judge Family Court since to stage evidence
hearing stage. Already WS filed and hearing started.
WS has been filed by the present petitioner, opposite party. It is at the stage of
hearing already started.
Evidence concluded.
Already PW1 is examined and cross-examining some parts and then report.
The evidence has started. PW1 has been examined. PW1 husband has been examined in part.
In part.
It is submitted that by transfer of the matter to Puri would not help either of the parties. Stop. Today or Mr. Hussain, today or some other time?
Regarding
the matter not to be transferred from Cuttack.
today, I'll withdraw minutes.
Okay. The petition has been filed under section 24 of the Civil Procedure Code, the Code of Civil Procedure. which provides thus 24 general power of transfer and withdrawal. Both of you can take your seat. I'll take some.
Yes, sir.
You take your seat. One ta quote kore debe. Apparently, the section 24 mandates issuing notice to both the parties. Therefore, convenience of both the parties is to be considered by the court before directing transfer of the matter. The learned counsel for the petitioner relies upon the decision dele. Decision rendered by the Honorable Apex Court in Sumita Singh versus Kumar Sanjay and another, colon AI 2002 SC 396. Apparently, the said decision does not is of no avail to the petitioner, but the fact that the petitioner therein, the wife in the marriage, sought for interstate transfer of the proceeding, matrimonial proceeding initiated against her in Ara, Bhojpur in the district of Bihar. She wanted, she had prayed for transfer of the matrimonial proceeding to Delhi, where she was working. And her parents were residents of Gurgaon. It is upon directly against you. It is the Gurgaon transfer by the Supreme Court.
It is.
और यदि कोचन जे पापा को पेरेंट्स को पापा को जीवे पेरेंट्स होते गुड़गांव रे ये तो दिल्ली ट्रांसफर कर देवे
नियरेस्ट
कोर्ट गुड़गांव टा कोर्ट
गुड़गांव हरियाणा
अवतल
पार्ट ऑफ
अपन जान चोती तो कोन
एनसीआर
नियरेस्ट कोन हो तो गुड़गांव ट्रांसफर करते ना पापा मां दिखता ना अपन जोटा कोचंती
इट इज दिल्ली एनसीआर
she sought for where she worked. Delhi NCR and Gurgaon doesn't exercise jurisdiction. Gurgaon is separate. That is how the bail jurisdiction is separate. In Noida and Ghaziabad, earlier there was no anticipatory bail. So they used to file a writ petition in Allahabad or Lucknow bench. This is not, in fact, you should mark these things. Which don't cite decisions, so it doesn't help you. This is not, I'm not criticizing. This is the way we have been discussing. No, you have made your point. But you must have thought that the parent, because you are saying that parents are staying in, because you are not sitting before High Court. As I have been telling you, Hyderabad is out of question here by this court. Working and not to the place where her parents were staying, that is Gurgaon in Haryana. Section 9 of the Civil Procedure Code. Section 9 of the Code of Civil Procedure provides thus. 9 ta quote kar debe. Courts to try all civil suits unless barred. Up to impliedly barred porjanta. Then Section 19 was the Family Court Act. Mr. Mohanty, jurisdiction?
Section 19.
19.
Again.
The family, Section 19 of the Family Courts 19. 9 bote. 7. Section 7 of the Family Courts Act provides jurisdiction. Family Courts Act, right. 19 bote Hindu Marriage Act.
Hindu Marriage Act.
Section 7 of the Family Courts Act provides for the jurisdiction of the family court. Section 19 of the Hindu Marriage Act provides for jurisdiction and procedure and is reproduced herein. 19 of Hindu Marriage Act produced content. Upon perusal and consideration of the aforesaid legal provisions contained in Civil Procedure Code, Family Courts Act, and the Hindu Marriage Act, in considered view of the court, this court, the court at Family Court at Cuttack is the proper court having jurisdiction. Convenience and perception of the wife cannot be the sole factor for deciding jurisdiction when the statute and the procedural law is otherwise clear, as has been indicated above. The prayer for transfer of the matter from Family Court Cuttack to Family Court Puri is accordingly rejected. The the parties to the litigation before the Lord Judge Family Court shall cooperate in expeditious disposal of the matter, as the matter is already at the stage of evidence and hearing. The Lord Judge Family Court shall proceed in accordance with law for expeditious disposal of the matter. The petition stands disposed of with the aforesaid appropriations. You are a second generation lawyer. You are second generation or first generation? First generation. So that, in fact, you are preparing well. Actually, first generation, Mr. Mohanty is also first generation, I think. So they are more, what you call, insecure. So they try to prepare more. Yes, next. Yes.
Item 27.
34.
You have a matter.
Item 34, madam.
34. What's your name?
I am appearing for the opposite party, Advocate Adisha Mahant.
Acha. See, they did not inform you. They have taken adjournment actually.
Oh, they have not informed me.
No, this usually happens. They will say that even if I repeatedly say Mr. Subhash Chandra Pradhan for the petitioner, Ms. Adisha Mohanty for the opposite party, एकाठी order लिखी दो दीटा जो अच्छी same appearance अच्छी. The matter being in the list for hearing under the heading, you are appearing in VC in this matter.
I have appeared in VC.
For admission was mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding. He submitted that he will file rejoinder to the petition, rejoinder to the counter filed. Upon counter file, you have filed counter.
I filed objection affidavit.
Okay. It was submitted that the petitioner will file affidavit, the rejoinder affidavit in response to the objection filed by the opposite party. Stop. When the matter is reached and when the matter reaches during day's proceeding and called, the learned counsel, Ms. Mohanty for the opposite party submits that she has not been informed. Stop. तीन आठ रे चले बता
My lord, the opposite party is a little restless since the matter is stayed before the family court. So, and she has some personal problems. She wants the divorce.
What do you want?
Lord, any time in July?
Okay. Though the matter was directed to be listed in the week commencing 3/8/2026, apparently in the absence of the apparently in absence and without intimation to the learned counsel for the opposite party, it shall be listed
We commencing 27.
in the week commencing 27. But 27 3 are very proximate. At least you have to get some semblance of respectability. Will be listed in the week commencing 27. Copy of this order shall be forwarded by the registry to the learned counsel for the petitioner.
Okay.
Yes. So Bhukta,
My lord. I'm
item
sorry.
27.
I'm sorry, my lord, while it was
No difficulty.
the criminal proceeding was filed by the wife under section 125 of CRPC. That is at judgment at page 37 annexure 3, wherein my lord award was passed directing the husband to pay 6,000 to wife and 4,000 to son, my lord.
Yes.
And this was passed on 2024.
Yes.
Prior to that matter in 2017, there was a decree of divorce was passed. Maybe it is expired decree of divorce, but a decree of divorce was passed that was never challenged by the wife. And thereafter the husband married second times. After married so many years, after the decree of divorce which was passed in 2017, after 5 years, this 125 proceeding was passed and that was entertained by the Run Court.
It has to be.
And 10,000 was passed. But what happened in the meanwhile?
Because the husband goes on divorcing and marrying. So that is a 125 is very specific. Divorced wife can claim maintenance, and obviously the child has never got divorced from the husband. I'm sorry, father and mother. The child never gets. That is a 125 is very specific.
And
now,
problem
if the wife gets married, then she will not get maintenance. That's a different thing.
There is interestingly wife is staying with. But that is there.
How does it matter? Husband goes on marrying and wife staying as
wife prior to marriage he was.
Whatever. You should have taken a decree on merits. The expected decree to get married will haunt you for the life.
She did not appear. In spite of that is also the order sheet shows. But here, my lord, what
6,000 and 4,000 is not.
No, 6,000 for I'm not.
He is too minimal in today's world.
No, he was a computer operator at that moment. Now he has obtained.
Now she will after marrying for the second time, he will renounce the word and become a sadhu.
No.
So that he will earn money out of pravachar. How does it relevant, Mr. Gupta?
I'm saying, my
senior to argue this thing. Please,
I am just saying, my lord, there is a delay of near about 400 days because I have to attend my father who was a cancer.
When I say delay, I am not issuing notice. I have already today have. So I will pass the same order.
Here,
delay I am not condoning.
And here
you have to satisfy me on merit.
Here out of 2,30,000 area, I have paid 1,40,000.
So file that affidavit.
I will file affidavit.
That you do.
I will file affidavit.
So सेटा अपन affidavit already direction अछि. सेटा delay order ता कोत रही ना. 18 रे जाय सेटा करिबे. ना. अपन को डाकी छि ना. केते लोग अपन को केते डाकी. ମୁଁ କଣ ଏପଟେ ଡିକ୍ଟେସନ ଦେଇଦେବି ନା ଆପଣ କଣ ଗୋटे ଚାଲିଛନ୍ତି ପୁରା 26 ଆଜ୍ଞା 26 ଠିକ ଅଛି 18 26 এটা লেখো at Mr. Diptiranjan Gupta for the petitioner opposite party black. The petitioner before this court is the husband in the marriage. After obtaining an ex parte decree of divorce, he has married for the second time. The wife in the first marriage and the child born from the said wedlock approached the learned court in learned judge family court, Jaipur, in criminal proceeding number 4 of 2022. seeking maintenance under section 125 of CRPC. Seeking monthly maintenance under section 125 CRPC. Into brackets, since repealed and substituted by perimeter provision contained in section 144 of BNSS 2023. Stop. The opposite party wife, the wife and the child claimed maintenance at the rate of 10,000 for the 10,000 for both of them, and 7,000 for medicine and school fee for medicine for medicines and school fee of the child. The petition was favored, however, directing rupees 6,000 per month to the wife and rupees 4,000 per month to the son. Stop. Agreed by the said order, the petitioner seeks revision. After should reproduce this. One should have dena 13/7 सुधा देबे 20/7 रे आसीबो.
Okay. Obliged.
Yes. ना लेटर चाहूँ दे पड़.
नहीं
ठीक है. नहीं तेरे साथ सब 4-5 टावर देगा. Complete करना था. Thank you.
Arrange